it's fine.
Okay. I think people will figure it out that it's not me.
Hopefully.
Okay, thank you. Hi, good evening. This is Fran Backstrand, Chairperson of the Zoning Board of Appeals for the Town of Northborough. This is an open meeting of the Northborough Zoning Board of Appeals, and it is being conducted remotely consistent with the Governor Baker's Executive Order of March 12, 2020, due to the current state of the emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, the town of Northborough has been advised and directed by the Commonwealth to suspend public gatherings, and as such, the governor's order suspends the requirement of the open meeting law to have all meetings in the publicly accessible physical location. All members of the Zoning Board of Appeals are allowed and encouraged to participate remotely. The order allows the Zoning Board of Appeals to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. Members of the public who wish to view the live stream of this meeting may do so by going to the Northborough Remote Meetings on YouTube via the link listed on the agenda. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. Okay, well, thank you everyone for your patience. This is the October 27th, 2020 meeting of the Zoning Board of Appeals, and it is past the hour of 6 p.m. Okay, due to scheduling conflicts, we are going to start with the continuation of the consideration of the petition of Amy Paretsky and Joanne Kraus for the appeal of the current conclusion of Robert J. Federico, CBO, Inspector of Building Zoning Enforcement Office, that the property located at 329, 333 West Main Street, map 81, parcels 13, 14, and 15 in the Business West District are now considered contractors' lots. Okay, so on the phone with us, we do have Town Council Dave Donetsky, and I am now going into the attendees room to find the appellants. And okay, so I see Amy and Joanne Kraus, who I've just added to our chat box here. And in addition, I'm going to look and see not the actual appellants, but there are abutters who have retained legal counsel. His name is Attorney Mark Lanza. I'm going to add him. And then Mr. Lanza, if the residents are, the residents, I'll have to find them and add them as well.
And there's also George Connors, who is the attorney for the property owner.
Okay, I got George, and now I just have to get the, and I apologize to the appellants, the Leonards.
Hi.
Oh, there they are. Okay. So I see Scott. The Leonards are on one line. Is that correct? Yeah, there they are. Okay.
Yes, that's correct.
All right. Thank you. Okay. And then I'm just going to, I don't know why there's such feedback, but okay. Oh, it went away. So that's fabulous. Okay. So before us this evening, oh, that's terrible. Am I the only one that hears the feedback?
No, I'm hearing it.
Can you hear me?
Yes. So I'm going to ask everyone who is not to put yourself on mute so that we don't get the feedback, and see if that doesn't make it a little bit better.
Excuse me.
Yes.
I can't see myself, so I don't know how to mute it. I don't see myself.
Okay, give me 1 second. I can mute. Oh, okay. I just muted you. Okay. Hopefully you'll be able to unmute, but I'll work that out when we get there. Okay. So to the members of the zoning board, we did ask town council to weigh in on two issues that were outstanding from the hearing that we had last month, and they were related to whether or not the special permit of 1987 conditions stand in relation to a continued use that had not been suspended for more than 2 years, as well as whether the building inspector's determination that the use of the property of a contractor's yard is the same as that was permitted in 1987. I'm going to assume everybody has received it.
Yep.
And that they have reviewed it. In addition, we received a letter from the Leonards, who have retained again Attorney Lanza, and his interpretation of the situation as well. Though I will note that his was received before he had a chance to see town councils. So whether or not that changes anything, we'll know when they have an opportunity to speak. So to start, the members of the zoning board, do you have any questions specifically for the town council related to his written decision or his written interpretation? Okay. Does town staff have any questions for Attorney Donetsky regarding the letter that he sent in his the letter he sent?
No, I'm all set, Fran, but I just want to make sure that that the board members all have it. I sent it out yesterday and then I sent it out again today.
Mm-hmm.
Okay.
Okay.
Yeah.
All right. So I mean, I will just
Fran,
to
I think Dick has a question.
Oh,
a
sorry. Go ahead,
question.
Dick. Thank you.
I still have a question about the timeliness of their filing this complaint. They had 30 days to file it from the date of the building inspector's decision. And my understanding from the town clerk is that he didn't receive the official request and a check until June 11th or thereabouts, substantially more than the 30 days. Has that been resolved?
Fran,
Kathy?
I was going to say, I
Okay.
can either answer that or Mr. Janeski, but I had asked town council that question after one of the prior meetings, and statutorily, the appellant did meet the requirements of the state statute in that they notified, although it didn't originally come in on our application form, but they did provide the notification to the town clerk, and that is sufficient enough that the town was put on notice that they wanted to appeal the decision.
So
And
it's not a
Madam
formal
Chair-
process. Yes, Jeff. Oh, Mr.
This-
Zaneski, sorry.
Just confirming that is my view, that in substance, the 30-day period, taking into account all of the facts here, which I won't recite, but taking into account what was filed and when it was filed, that yes, my view would be it is timely.
Okay, thank you. Okay. Any,
Madam Chair?
is that Brad?
Yes.
Thank you.
Sorry. Yeah, one of the questions I had, and a little confused about, I know the 2-year window of when it is a contractor's yard versus not a contractor's yard. I'd like a little more interpretation regarding the decision of town council on how they feel it's contractor's yard versus non-contractor's yard, and if it's grandfathered or not. If that makes sense.
Related to the 2-year of non-use?
Correct.
Okay.
Yeah.
Mr. Zaneski?
Yes, Madam Chair, that was essentially the last item, and
Mhm.
the bylaw, as authorized by statute, allows for a non-conforming use to be extinguished if it's not used for a period of 2 or more years. The information that I reviewed, I did not have a basis to disagree with the building inspector's determination of fact that there has not been a lapse or extinguishment by reason of non-use for a 2-year period. So I didn't have any particular individual view on that, but based on all the material that was provided, I did not have a basis again to disagree with the building inspector.
Can I say something or not
Oh,
yet?
no, not yet.
Okay.
Thank you.
Okay.
If I could, Bob, if I could then ask you, because it's going to, or will be asked, what did you base your determination that it was the use was continuing regardless of the volume, I would assume, but
The previous owner, ACV Environmental, was on site at all times. And even though the level of activity has ebbed and flowed over the years, they were able to retain the maximum allowed or maximum amount of activity that they had been doing. My understanding is typically that when an owner of a particular company, as long as they still getting mail and their sign is still up and they can still conduct business, that is allowed to stand, even though they may be down to one truck or two trucks or no trucks for a short period of time. They still have the ability to ramp back up, and that's how I made that determination.
okay, thank you. Okay,
Madam Chair, I have a question for town council. Just in regards to the 2 year, so the section 2. So if the 1987 special permit states that 329 West Main is able to be used as a contractor's yard, but at some point over the period of between 1987 and present, 329 is no longer used as a contractor's yard for a period of 2 years, even though it is still active. Would that constitute an abandonment or a cessation of use or loss of the grandfather of the use?
I would answer that through the chair by repeating somewhat what's in my memorandum of yesterday, and that is I take the building inspector's determination to be that what has occurred based on his examination is within the protection of the non-conforming use and as authorized by that 1987 special permit. So there may be elements that may not be present on a particular day, but I understand that the sum determination is that the use that was authorized, there was a presence of it in some form or another maintained during all this period of time such that the use continues. And so I guess a quick, maybe more direct extraction to your question is, in my view, it wouldn't be the case that every element that was authorized would need to have existed on all days during the period of time in question. And in that sense, I would follow along what the building inspector said, that certain activities taking place all within the scope of what is the protected use would essentially continue that use.
Okay, so that was the second question, which had to do with the 2 years and the determination that it was a continued use. I mean, it was not abandoned for more than 2 years. The first question was related to whether a contractor's yard today is the same as a contractor's yard as 1987. Did any of the board members have any additional questions for either Attorney Dineski or Bob on that, the building inspector? Okay, all right.
Yeah, Madam Chair, I do have another question.
Sure.
Yeah, I mean, just being on this board and reading the appeal, still a little confused on how do we determine. I know contractor's yard is such an ambiguous term. How, and this may be more for our zoning enforcement officer, Mr. Federico. How do you determine what's a contractor's yard versus what isn't a contractor's yard based on the appeal? things that have been denied in the past or things that have gone in front of zoning versus this appeal today. Is there any determination you can give us a little more detail into what you think?
I think he's getting something.
Press a written statement ready to go because you knew that was coming.
Hold on just a second.
No problem.
Going to the definition for a contractor's yard. Excuse me if I don't look into the camera, I'm reading here.
No problem. And actually, Mr. Federico, what page is that on? I just want to.
7-38.
Thank you.
Do you have it?
Yep.
Yes.
Okay. Contractor's yard, parentheses C, lumberyard, construction contractor's yard, or other open air establishment for the storage, distribution, or sale at wholesale or retail of materials, but not including salvage materials, merchandise, products or equipment, fabrications of subassemblies, or parking of wheeled equipment, providing that all operations shall be such as to confine to the premises, disturbing dust, noise, odors, or other objectionable effects, and provided further that such use is not hazardous by reason of the potential of fire, explosion, radiation release, or other casualties.
Okay.
I do not know if that is the exact same definition of a contractor's yard that was used back in 1987. But when you look at what the decision is, if you read it through context, and if you see what is actually out there, and if you take a look at what I just read, I believe it's a pretty consistent match.
Okay.
Okay. Thank you.
Thank you. Okay. At this point, I know, Ms. Kraus, you said that you wanted to speak. I wanted to give, if Attorney Lanza has any questions directly related to the decision or the letter from Town Council, because Town Council will be departing in about 20 minutes. I just want to give an opportunity for that conversation if needed. Mr. Lanza? And you would have to unmute yourself. There you go. Hi.
Okay.
I'm
Ma-
finding him unintelligible.
I'm
Mark?
not-
That was unintelligible.
Yeah, Mr. Lanza, we could not hear you. So everybody is muted except for me. So I'm going to mute myself for a moment and see if that doesn't make it better. No, unfortunately, the feedback is greater than what you're saying. So,
he's going to have to call.
okay. So, Mr. and Mrs. Leonard, your counsel is not able to communicate with us. So at this moment, I'm going to just go back to the appellants, which are Ms. Paretsky and Ms. Kraus, to see if they have any additional information that was not shared with the board at the last meeting. So Ms. Kraus, you wanted to speak, please?
Yes, I do have a presentation.
Is it additional information not previously presented?
I think so.
Okay, and is it directly related to the two questions that were still outstanding as to whether the building inspector's interpretation of the use and the 2-year period are not accurate?
Yes.
Okay.
I can say I called, hold on. Okay. Can you put yours on mute, please? I can say I have Mark here. He's on speaker, so I'm going to unplug my headset so he can speak. But first, I want to just say that we called the company today, and they said they have not been in operation at all in Northborough for 5 years.
And what company was that?
This is ACV, Allstate Power Vac. We also asked them, where did they move to? They said they moved to Framingham from here, and then they moved from Framingham to Norfolk. They haven't been in Framingham for 4 years either. So they have not been in operation in Northborough for 5 years, according to the company themselves.
Okay.
So that is definitely in dispute.
Okay. Okay. Did you have
also heard from others that the company had forwarded their mail and their phones to Framingham.
Okay. All right. So I'm going to all right. So you indicated that you spoke with someone directly at ACV.
Yes.
Do you have something? Can you share a name of that person with us?
His name is. Mark Weigel, Weigle. Go get that phone number.
Okay, thank you.
Number?
All right, no, that's fine. I just wanted for the record, not. Okay, and so that is one. I don't know whether they are one tenant or owner of the building. Mr. Federico, do you know whether they are the owner or one of the tenants?
ACV was the owner.
ACV was the owner of the building up until about a year ago.
Okay.
Right, and they haven't operated there in 5 years.
Okay, all right.
But they had the ability to operate there.
But they didn't operate.
All right. Okay, thank you, Ms. Kraus.
Okay. Doesn't matter if they have the ability. It just matters that they didn't operate.
Okay, and Ms. Kraus, I think that the interpretation of the law that town council just shared with us was that the ability does matter. And so
he didn't say that. He didn't say that.
Ms. Kraus, you said you had additional information that you wanted to share with us?
Well, I haven't been given the opportunity to make a presentation yet.
Oh, go ahead. Well,
so I would like to present my slides if that's okay.
Go ahead.
Okay. How do I do that? How do I share my desktop?
I have no idea. Well, I see a share screen at the bottom of mine. Do you see a shared screen at the bottom of yours?
I believe it's through our host.
Okay.
Becca, if you're there, is it you that has to do something so that one of the abutters can share her screen?
All the panelists should have the ability to share screen by clicking the share screen button on the bottom.
Okay.
It's a green button. It says share screen, and then it'll share your desktop or whatever you're looking at.
I have the same problem.
You see that, Joanne? Do you see that?
I don't see. I see a mute button and a raise hand. That's it. And a leave.
All right. If you put your cursor towards the bottom of the screen, several things should pop up. Like participants, share screen, record.
It's not coming up. I don't see everything that you see. I'm just seeing a mute button with audio settings.
Okay, just give me 1 second, Joanne. I'm going to promote you to panelist, and that should give you the ability to share. So just hold like 10 seconds.
Okay, thank you.
Okay, and while they're waiting, Attorney Daneski, can you elaborate on what abandonment requirements are and or use, since we now have that information that the appellant has shared because I don't want to hold you up during the presentation.
Madam Chair, abandonment does require a level of intent, but under the bylaw provision in question, there's not an abandonment provision. It's if it's not used. And I would say that while not all elements of a use would have to be exercised in order to maintain the protection, as I stated earlier, that there would, in my view, need to be some level of use that falls within the scope of what is protected as the non-conforming use.
Okay.
And that kind of points out the distinction between abandonment and simple non-use.
Okay. All right. And while we're waiting for the slides, does anybody else have, Paul?
Yep. So if we're not talking about this case, right, and we had a non-conforming use that was, say, a gas station, right, in a residential zone, hypothetically, and the gas station is selling gas from 1970 until 2010, but then stops selling gas, but the structure's still there, the gas tanks are still there, okay, but he's not selling gas. And then now 10 years later, in 2020, someone wants to buy the gas station and use it. They weren't technically using the gas station, right? But it was still there. Under our bylaws, section in I'm talking the third page, a non-conforming use or structure that has not been used for a period of 2 or more years shall lose its protected status and be subject to all the provisions of this bylaw. So
sorry, Paul, what page is that? I don't mean to interrupt. What page?
It's just on the last page of the Attorney Dineski's letter, where he states
the letter. Okay.
The section 3, where he goes over the bylaw.
Right.
A non-conforming use or structure that has not been used for a period of 2 years shall lose its protected status and be subject to all the provisions of the bylaw.
So would that gas station be able to start pumping gas again?
Right. Hypothetically.
Yeah, sure.
Madam Chair, is that a question for me?
Yes, I'm sorry. Yes.
So in my view, if there were no element of a protected non-conforming use that occurred during a 2-year period, and to take this example, no element of gas station operation occurred for a period of 2 years or more, in my view, that would be a reason to say that the bylaw provision would apply.
Okay.
But in other words, that would be absence of any of the use components.
Okay. But if they just stopped the primary use, which was pumping gas, but continued to sell, cigarettes because they had the convenience store, that would be different, potentially.
Every case will rest on its own facts, and I think we could have perhaps examples
sure.
to infinity. But I think the straight question is the essential elements of what would be a gas station operation. If none of those existed for a period of 2 years, that's the easy question.
Okay.
But if none of them existed, I would say yes, the bylaw providing for extinguishment of that use would apply.
All right. Paul, did that answer your question?
Yes, that's it. Thank you.
Okay, excellent. All right. Thank you very much. And Attorney Dineski, if you have to sign off, understandable. It looks like Ms. Krause is able to share her screen with us now to do her presentation.
Okay.
Okay, so I'm just going to say that Mark Lanza just texted me and says I could quote him legally. The ability to operate does not matter. That they did not operate stops the 2 years clock. So that they did not operate for 5 years means that clock has stopped, and that they can no longer use that property as a contractor's yard. Okay, so so I just have some pictures here of the contractor's yard in use, full blown, and this was well before any ZBA has given them the ability to do so. This is our neighborhood right here, as you can see, Old Colonial and Buck Hill Road. You can see This neighbor right here practically touches the property back here, and these are the buildings. This is a Zoom picture taken not too long ago, and there's basically nothing going on in this whole area. We have 15 houses here. We have 15 wells. We have many small children and families who play in this neighborhood, and we purchased our properties based on the zoning bylaws of this town. And we trusted that the town would protect our well-being. From the last meeting, I just wanted to quickly go through, what we talked about, a little bit of history of the site, and then the loss of non-conforming grandfathered use. If my points are moot now, then you can tell me to stop. But we have spent some time preparing this, and I'd just like to go through them real quick.
Right. But some of this was discussed at the last meeting. So this is just supporting your position that you articulated at the last
Right.
meeting. So if you could
Okay.
just stay specifically on the ones that relate to not what they're doing, but why you believe that this shows that the 2 years has been non-use, and that the contractor's yard by the definition in our zoning bylaw is not being met, should it be grandfathered in?
Okay, so basically, I just wanted to show a few more things about what's going on there. But if I can't do that, then I'm not sure what I should say. I think I have proven that the property has not been in use for 5 years, and that the contractor's yard goes away after 2, according to our laws.
Okay.
And
the trucks that are on the property are?
And Labradini also, when we were before you 1 year ago, Mr. Labradini also presented the fact that there's been nothing going on there since 2017 either. He said that as well. Actually, yeah, it was the lawyer who said it, not him. So right now there's more than 12 vacuum trucks being stored on that property on gravel. And this is dangerous to our drinking water as well. Mr. Federico sent a letter asking them to take the trucks off the property, but they did not. We saw trucks are still parked there as of Sunday. These trucks are hazardous waste vacuum cleaning trucks. And we don't know what's in them. We don't know who's leasing the trucks. We don't know who cleans the trucks. It's basically, we don't understand how this can happen when there was never supposed to be anything parked on 333 West Main to begin with. That was denied countless times, and we have the backup to prove that. This is from the website that we just found this the other day. Liquid vacuum trucks. This is what they're renting out to people right in our backyard. These trucks are designed for collecting and transporting liquid, hazardous and non-hazardous, and semi-liquid waste. Non-hazardous waste refers to a range of materials, but is most often considered sewage and septic materials. Stainless steel liquid vacuum trucks are designed to collect, store, and transport chemicals with corrosive properties, such as strong acids and bases. These are the trucks that are over there. There's more than 12 of them on gravel. Just on Sunday, this particular truck, MER Environmental, is worse than what Mr. Lamborghini was planning to put there. The jobs listed on MER's website was remediation, soil remediation and removal, transportation and disposal, tank removal, hydro evacuation, waste management and recycle, wastewater treatment, transportation, and I mean, all of these things are being vacuumed up in these trucks, and these trucks are coming back to this property. Granted, they're supposed to be empty, but there is residuals, and again, that was the reason why they were never allowed to park here. And the residents of Buck Hill, we have revisited these properties, and this attempt to put hazardous materials and companies industrial companies on this property, and I've been in this for a long time, and I don't understand how when the ZBA denies this keeps coming back up. So it's confusing to me. This will set if we allow this, it'll set a precedent that it's better just come in here, do whatever you want, rather than go before the town and get the proper permits to operate. I don't need to go through this again. But like I said, we confirmed by calling today that they moved out of Northborough in 2015 and out of Framingham in 2016, and they're only been operating out of Norfolk now since 2016.
Thank you.
All right. I don't need to go through the law. Okay. So we just urge that you approve our appeal and that you uphold our bylaws and that you protect our groundwater, the residents of Northborough, and the abutting neighborhoods. Thank you.
Thank you very much. And I would just ask, since you did, breeze through it, which I do appreciate for timeliness purposes, if you wanted to send a hard copy to Kathy Joubert so that it is part of the written record, I would encourage you to do that. I know some of the pictures are in the original packet, but you may want to do that as well.
Okay, I just wanted to say thank you to Kathy and to Fred for sending me all the documents that I requested. I know that was a pain in the neck, but I really do appreciate all your help with this. And I wanted to also say thanks to the neighbors for supporting us and you guys for hearing me out.
Thank you very much, Ms. Kraus. All right, I'm going to ask Mr. Connors, who is representing the property, if he has anything that he wanted to add before I go back to the board for questions and then back to the audience.
Yeah, George Connors here. I presume you have the photos that we sent in recently in a cover letter about 2 days ago, and also a statement from ACV in writing with a additional material on their operations in the state, confirming that project had continually been operated in some form or fashion. He did indicate in that letter that there were various things that they did inside the building as well. And I would point out that Mr. Donetsky had indicated the Orange case. In the Orange case, a little bit after his citation, it talks about a change so significant that abandonment exists as a matter of law. And that's on page 364 of that particular case. I don't believe that has occurred on 329. In terms of the adjacent parcels that are at 329, I've been in engineering as an engineer for almost 50 years. And whenever we file plans, we use the address of a building that is there, notwithstanding that there may be several parcels associated with it. Read in detail the permit in 87, and notwithstanding it said there were septic systems. Yeah, there is indeed a detention basin on there and some areas that have been used as indicated on many of the photos that Mr. Zuras had provided in the most recent email we sent to the building inspector. I'm happy to respond to any more questions or comments.
Okay, Mr. Connors, this is Fran. I have a question. I don't recall getting something in the last couple of days with pictures or confirmation about AVC, but that could be me. So I just want to confirm with Kathy that is something the town at least received.
Yes, we did receive it from Mr. Connors, and I had sent it out originally to the board members when we received it, and then I sent it, I believe, yesterday to just to make sure that everybody had it for tonight.
Okay.
It's a cover sheet with, what's the date on it, Fred? The letter itself from Mr. Connors is dated October 19th.
Okay.
And then there's a series of photographs from, Google photographs.
Got it. Okay.
And then there's also a letter from ACV.
How come we didn't
Okay,
get
thank
those?
you.
Kathy,
Excuse me, Ms. Kraus, one moment. All right, so all the board members know what Kathy is referencing? And then Ms. Kraus just asked if if it was not sent out to the appellants.
Joanne, that should have been part of all of those emails and letters and documents that I had sent to you in those various emails.
No way, we didn't see that. No.
Okay, all right. Well, while we're getting that clarified, I do want to just correct something that Mr. Connors, when he referred to that orange law, I think town council said that our zoning bylaw only speaks to not use. And so it doesn't have to rise to the level of abandonment to be, not grandfathered. So that is not pertinent to our situation. But that doesn't mean that, so we're just going to base ours on whether it meets the non-use, not abandonment criteria. But I don't know, I'm looking at the faces of the board members and wondering if anyone has the October paperwork that Kathy is referring to. Okay, so far, Paul does.
I'm looking at it now.
Okay, there you go. Okay, so, all right, so at least I know that it went out. I don't know why it didn't get out to everyone. But all right, so we have now written information. Well, I guess I have a question. I want to go back to Mr. Federico, if I could, based on the partially on the presentation. If it is not being used as a contractor's yard, then what are all these trucks and businesses doing on the property? Or is it just ACV is just not using it? I'm very confused now.
I think it's ACV, and one of my questions maybe for later or now for that matter is, the welding shop, which has been there for virtually forever, could possibly also qualify as a contractor's yard. He's got outside storage of materials, outside storage of trucks. He does custom fabrication work. He's selling retail and wholesale.
All right.
So I would venture to guess that, ACV would not be the only company working as a contractor's yard.
Okay, so they're the owners of the building, but like they had many tenants doing different things in that building.
Right.
But let's say ACV has, picked up and, left and gone to Framingham and Norfolk or elsewhere. What businesses are all these trucks from? Are they not new tenants on that property exercising the 1987 contractor's yard?
Well, the welder shop has been there for quite a long time. And the other set of trucks is, I think the company is called New England Tree, and they are a tree removal service. Okay. They're not a landscaper. So they don't fertilize, they don't cut grass, they don't trim hedges, and they don't rake leaves. The only thing they do is tree removal. And I asked them what kind of chemicals that they're using. And they say the only thing they're using is the fuel and the oil for the chainsaws. And in the trucks. I said, what about fertilizers? They said, we don't do any of that kind of work. There were a bunch of logs from trees that were felled and brought onto the site. This is back earlier in the spring. I said that really should be gotten out of there. I mean, not only is it an eyesore, but it's kind of illegal, because it's like a temporary stopping ground before they get shipped up and disposed of. And I told them they need to deal with that.
But what about these other trucks that Ms. Kraus showed on? I mean, the one that was in front of the building, I actually went by today. It was there. I mean, I don't know what it does, but it was there.
That truck, by looking at it, is similar to the other trucks from the Truck-Vac leasing company. I don't know what it was doing there or when it was there. I don't know if it was parked there, which I think was kind of inappropriate. But there's a gate around back. Currently, I'm looking at the aerial photos from George Connors, which has basically an aerial photo from Google from the past bunch of years. And just about, with the exception of, well, there's vehicles there too. So in virtually in every photo, there is some sort of a truck or construction truck or some sort of vehicle that would echo the use as a contractor's yard.
Okay. Okay. All right. Okay. So, any additional questions at the moment from the board?
Well, just let me.
I'm sorry. Go ahead,
well.
Bob. Finish.
Over the years, there's also been steel storage containers out there and what appears to be dumpsters. And I know that the welding fabricator has kind of overextended his real estate within the property. And the owners have been working with him to reduce his outside pile, get it orderly, and get it cleaned up. The trailers that were no longer roadworthy, used for storage, have been removed. I haven't seen any dumpsters there as well. And again, to kind of answer a concern that was raised, is that these vac trucks come back. And I met with the owner of the operation, and he demonstrated to me how when the trucks do come back, they are visually inspected, they're documented with photos that they are empty. And the the residual, I don't know how they quantify it, but the tanks that I saw looked almost dry. But they document that both when the trucks leave the yard and when they come back. And they described to me that if a customer were to bring a truck back with anything in it, it would be rejected and there would be a substantial monetary penalty assessed on the lease agreement. So, hearing that, I was kind of put at ease about, what is on the lot overnight.
Okay. Okay. Paul, you had a question?
Yeah, I had a question. So in regards to 333, which is, if you're looking at George Connor's map, essentially the lot to the left, is that lot currently being used?
333 has a new septic system in it, and it's a gravel lot. And there's currently a plan to pave it and provide some sort of contained drainage. I think the board discussed that at the last meeting when they were talking about the granite retail sales and the granite fabrication, so to speak.
So the entire 333, right, is a gravel lot and it's not paved, right? And I think in the last meeting, unpaved lots are not allowed to have trucks on them.
Right, and I've asked them to remove the trucks from the lot.
And so looking at George Connor's Google Maps, which go back a number of years,
right?
These trucks have been there for a number of years, when in reality they probably shouldn't have been.
Well, it's one of the things that I've been unable to determine is right now under the current bylaws, parking and loading for industrial or commercial or business uses has to be on a paved surface. I don't know if that requirement was in existence back in 1987, so I'm not quite sure how to enforce it. I would suggest that best practice is for them to remove the trucks, get them onto a paved surface, and go ahead with the plans to get approval to pave it with proper drainage.
Okay.
I have a letter.
Okay, excuse me, Ms. Kraus.
I know I'm having trouble keeping my mouth shut.
If there's a little hand, if you raise your little hand, then I'll know that you want to talk. But it's fine. It's fine. Go ahead.
So I have a letter from the Board of Health directing that there is no parking allowed on 333 at all in 1987.
Okay.
I have it right here in my deck. I didn't put it up because I didn't want to bore everybody to tears, but I have a letter.
All right.
So much documentation proving that this property.
Right. Unfortunately, the two specific responsibilities that the zoning board has tonight is to determine whether the contractor's yard is a grandfathered pre-existing use and whether or not it's been more or less than 2 years since it had been used and therefore no longer qualifies. I mean, that's our only, the appeal of the zoning enforcement officer's decision was his interpretation that it is a contractor's yard and it hasn't stopped being used in 2 years. Everything else related to whether it's unsightly or not favorable to the neighborhood or whether the truck should be on gravel or pavement is not, unfortunately, relevant to what our authority is this evening.
So if it's illegal, it's not relevant either?
It doesn't pertain to whether or not it meets contractor's yard as a use. We're here to determine whether it meets the contractor's yard as a use and whether, if it does, has it continued without a break of more than 2 years in that use? And that's all we have because that is what was appealed. The zoning enforcement officer's decision that it does meet that criteria. Kathy.
I just wanted to point out, since some of you say you received the material, some of you say you didn't, but I sent it out at 3:45 yesterday. Yesterday afternoon. So part of that packet, which we had received back in August, or we meaning the town or the board, there's a letter from ACV that I won't read the whole letter because I think some of you have it, but in part they say at no time did Allstate PowerVac Inc. ever abandon or intend to abandon the operation of the facility or the use of the site. During the time we owned the Northborough facility that we operated out of, we acted as a dispatching and maintenance facility. The facility stored hand tools, field supplies, and commercial power equipment, among other things used in our operation. The garage was used to conduct preventative maintenance and minor repairs to the equipment. The outdoor areas were used to stage equipment, supplies, and vehicles. The office space was utilized for dispatching, coordinating, bookkeeping activities, and customer interaction, and the locker rooms were for staff and employees. And that's a letter that came from ACV in August. It's dated August 11th, 2020. So
and they said they were in business doing that when?
They said at no time since they've owned the facility have they not been there.
Well, see, that's just not what they said to me today.
Yeah, and I mean, it's not up to me, Joanne, but trust me, I believe you that you spoke to someone at the company and they said something differently. But
and I went by there every day. There was nothing going on there. There was no activity over there.
I'm just referencing.
Kathy, can you tell us just for the record, who was the letter written from and what is their position at the company?
He is the director of accounting. Okay. Of Allstate PowerVac Inc. doing business as ACV Enviro. Okay. And his name is Michael Dello.
Okay, thank you. Ms. Kraus, do you know what the position of Mark Weigel is? Okay, all right, thank you.
He answered the phone. He answered the phone today and said they haven't been there. They moved to Framingham 5 years ago.
This is my husband, Paul.
Oh, I'm sorry. Thank you. That was Paul Kraus speaking. Sorry. I'm sorry, Mr. Kraus.
He said they moved out 5 years ago to Framingham, and then 4 years ago they moved everything to Norfolk.
Okay, thank you.
That's what he said.
All right.
And that's all.
Okay, thank you. All right. Paul.
Sorry. So just one note with that letter. It also just references 329 West Main Street and not 333. So just going back to 333 for a second. This appeal, right, my understanding is that it includes both 329, which houses the building, the welder, what was ACV and whatever, and then also 333, which is the side lot, which on the map is where all the trucks are parked and everything else. I guess my question is, Bob, do you know what the history of that side lot is in terms of its use or the history? You know, because I think if we go back to 1987, when the special permit allowing the contractor's yard, right? That case is 329, right? Is it possible?
I just wanted, as far as staff wise, and whether it's this property or any other property, we always refer to the property that has the building on it. So there's 3 lots there that are all owned by the same entity. So when we talk about 329, we refer to that means the whole site, everything that is owned by, the owner of the property. And if there was a different owner, it would be referred to differently. So I don't know if that helps you or not, Paul, but when we talk about 329, it's the whole site, all 3 parcels.
But they were never considered one parcel.
Okay, Miss Kraus, I'm sorry. All right, so Kathy, if the zoning enforcement officer's decision that it is a contractor's yard, it's continued to be a contractor's yard, and so whatever they're doing there meets that criteria, would that then mean there's still the authority that the 333 was never meant to be a parking lot because it was gravel? Back in 87, it was supposed to be gravel and only used for septic to support 329. That would stand, and then he would have to strong arm them into getting the trucks off of it or pave it, because that's in violation of the 1987 special permit. Is that right?
Yeah. I mean, I think Bob can probably better answer it than me, but yes, and it's, I think it's separate than what you're talking about tonight. Right. I mean, the fact that a property owner is in violation, and Bob Frederico has been working with George Connors and his client to get that site, up to snuff. That's a whole separate issue that's going on. So are they parked there illegally? I guess the answer is yes. They're not supposed to be parked there, but that's something that, that we need to remedy in-house. And that's something that Bob has been working on, and I'll defer to Bob.
Okay, Bob.
If I may, again, I have not been able to get my hands on the zoning requirements for paved parking requirements dating back to 1987. That's why I've been a little bit hesitant on enforcing something, because if there was no requirement for paved parking for a business use back in 1987, it's really not something I can enforce. If by chance a paved parking area was required back then, they've been in violation since 1987. Notwithstanding, a portion of that lot had been paved at one point. It's very badly deteriorated. It's not a very large section at all. It's way over towards the western boundary of western property line. And I actually would not count that as a paved surface anymore. But at some point there was something that was laid down on the ground. So again, I don't have the hard facts regarding the 1987 requirement for off-street parking and loading. I could dig deeper again and see if I can find it.
Kathy?
But again, best practices to get that thing paved if they're going to continue to use it.
Yes. I believe that I have an 87 zoning bylaw, and I can do one of two things. I can check it while we're sitting here live in the meeting, or if you want me to send you all the section of the bylaw that I need to look up. Back then it was business B. I think this part of the town was called business B, we had a business A, business B, and business C. And I don't think that parking lots were required, believe it or not, back then. I mean, it behooved a property owner to pave a commercial property owner to pave his parking lot. But I can't say that I can honestly remember that from 1987, but I can either look it up for you now, or I can get you that material.
Okay, well, give us a second. To Ms. Krause's point, though, about having something from the Board of Health that said that because I assume because of the septic that you couldn't park there, would that is there a way in which that would then make the 1987 special permit null and void, or any of these infractions that may or may not have been going on for the past 30 years make that special permit null and void? Or are we still with a special permit that is current and only addressing whether or not the current situation meets that criteria? I mean, can you be in violation for 30 years of a special permit without consequence? I mean, you're grandfathered in for another 30 years?
There's and again, I'd have to investigate this because it does not happen very often. I believe that there is in the state 40A statute that speaks about, I think it's illegal uses that has not had any formal complaints against it for a period of longer than 6 years is deemed to be okay. It's a rough paraphrase and I may be incorrect, but I do believe that there's some sort of an expiration of the statute of limitations, or whatever you want to call it, that after a certain period of time without a formal complaint or formal action against the offender, that it's basically dismissed.
Okay, thank you. Paul, I'm sorry, you had a question and I cut you off.
I forget what I was going to ask, but I guess it was something to what you were asking in terms of, if they're using 333 or the side lot as a place to park, if their point is, hey, we've been using this for, since 1987 and parking all of our trucks there, but the trucks shouldn't have been there from the start. Is that a continuation, or is that just, hey, you shouldn't have been parking there from the beginning? I don't know. I mean, like to say that, oh yeah, well, we've been parking our trucks there. We've been doing it for X amount of years. And, I don't know if ACV left or if they're here or whatever, but if they should have never been there,
Okay.
is that a grandfathered, or is it, well, you shouldn't have been parking there.
Right. Yeah, right. My point exactly. Okay.
Right. And I don't know if that's a question for, the current owner, or.
I don't know. Well, no, I would imagine it would probably behoove us to have the Bob and or town council tell us what that actually means. Then the person, not that I'm saying Mr. Connors would say something that would just to benefit him, but I would want a more neutral party, I think, explanation.
I agree.
So, all right. So I feel like we've got
Madam
a lot
Chair?
of information, but
Madam Chair?
for every piece of information, I feel like I have another question. Go ahead. I'm sorry, Brad.
Yeah, so a few things here. I mean, I've been looking at the 1987 decision, and it's specifically for 329, not 333. Regardless if people were parking on 333, I feel as though that's violation. I've grown up in Northborough. I grew up on that side of town, and things were a little different in the 80s. We would have taken any type of business we could get, but now people are paying more attention, and regardless of what they're doing on 333, fact of the matter is the decision in 1987 specifically states 329, even though we kind of just lump it in all as one. And but one of my questions, so ACV, are they still the owner and they're just renting this out to New England Tree, or are they exchanging ownership?
I believe they're no longer the owners.
I think they sold earlier this year to someone. ACV no longer owns the property.
They sold to S&S Realty Trust back in April to address the issue about the strict 329 address. if you look at the 1987 decision, number 2, it talks about the boundaries of the project, which would be the contractor's yard. It expressly includes the other 2 pieces of property.
Okay.
It encapsulates 2 parcels totaling 45,311 square feet.
And so we're looking at that as 329-333. Is that what you're saying? Okay.
Right.
Okay. And my next piece is, I know variances are based on the property. Special permits, though, they don't carry with change of ownership, do they? And so in this case, regardless if it is according to our bylaws, changing a non-conforming use to another non-conforming use, shouldn't it have gone at least to a special permit in front of us, changing ownership?
Kathy?
Whether it's what am I trying to say, less detrimental or not?
No, the special permit, it only goes with the owner if the decision is written that way. And I believe that this board has only done that a couple of times just in the past year or 2 years.
Okay.
But if Brad, something to that you had asked earlier as far as something about the use, I just want, good, bad, or indifferent, I just want to point out to people that and I know everyone is focusing right now on the ACV and the company that's there now, but the welder has been there since I believe since the late 80s. So he's always been there and operating basically a contractor's yard in the back. He has tons of material, and he's sort of just taken, over the years, taken more and more of the pavement as for his material that he stores outside. And then and I don't know the name of who's there now or who used to be there, but there's always been a tree company that has operated out of that site. And their equipment has always been there. So I know the focus tonight, seems to be on the trucks that are there for that other company, but those other 2 companies have been there for a very long time and operating out of 329, with contractors' yards.
All right, thank you, Kathy. And I want to apologize. I just realized that there are people in the audience with their hand raised. And I apologize that we have been monopolizing the conversation. I want to start with Amy because you are in the group, but I see a hand, so I don't know whether that was before or after you came in the group. So if you want to unmute yourself, or I think you should be able to just unmute yourself. There you go.
All right, can you hear me?
Yes, thank you.
I don't know if you can see me, but I'm not in the panel. That's why.
Okay. Yeah, you are on our screen, so sorry. Okay, I'm sorry, and I apologize again.
Okay, I guess one of my questions, the main question too, is why did the zoning enforcement officer deny a contractor's yard in 2017 twice, and it have to come in front of you when all of a sudden in 2020 it's allowed by right? Like why in 2017 it wasn't allowed? That was one of my questions.
Okay, all right, let's do one at a time. So I'm going to ask Mr. Federico if you know which applicants the appellant is referring to and whether the merits were different.
They were both involving the use of chemicals in a groundwater protection overlay district. Okay, and that is when I said you would need to go and appear before the ZBA. Those are zoning interpretations, not determinations. So I did not reject them. It was the applicant's opportunity, if they wanted to pursue it, to apply to the board.
Okay, thank you. Okay, go ahead, Amy. You might be muted again.
Okay.
Sorry, we can hear you.
The new applicant also with the vacuum truck rental, that is also chemicals and hazardous waste and sewer. And so I think chemicals actually isn't part of the definition for contractor's yard. So that was one of the things I wanted to say. But vacuum truck rentals also doesn't fall under contractor's yard. Vacuum truck rentals that's industrial and hazardous waste. That's totally different. And we did write to Bob initially in April, and per his letter, the tree company started in 2013. Anything after 2009 bylaw changes to expand, which would be including a tree company that had trucks, that would be considered an expansion of use. So all those tree trucks that are parked there are also illegal non-conforming. He should have come in front of the ZBA because he was there after 2009. In June, Bob asked that the trucks leave, but they're still there. And I noticed, like he said, that the tanks are almost dry when they come, and it's the applicant who's checking his own trucks. And I just wanted to make a point that if he had an enforcement in June and he's still not moving the trucks, and he had an enforcement to take away logs in April, but they're still there, how can we trust that he's actually checking the trucks? Like vacuum trucks like that should be in front of groundwater. I'm on the groundwater committee. I wanted to know if Mr. Connor's letter, we never got a copy of that. Did they have any record of their use? Like, were there truck logs that they came back and forth to the site, or were they just an office?
Oh, sorry. I'm sorry. I just hit.
I didn't get to see the letter, so I'm not sure if it included any, did it include logs of the trucks coming and going?
Okay.
Kathy or
Bob? Oh, all right. I wasn't sure. I'm sorry, Amy, because there are several things that you asked. I wasn't sure whether you were running through all of them, or if you want to stop at that moment, then there were a couple of things that she was asking. And I guess just to clarify, if a piece of property is deemed a contractor's yard as an allowed use, who determines who they can rent to, and at what point is that determination made? Because to Ms. Paretsky's point, if the tree company came in 2013, but it was in their expectation was, well, I'm just going to start doing business out of a contractor's yard, who decides whether the individual renters meet that same use? I think that's the nature of the question.
I believe it stays narrow to the use and not the business arrangement, whether it's owned, leased, rented, or borrowed. I believe it's strictly the use of the property and not who's on it.
Okay, interesting. Okay.
In my readings, oh, sorry.
Okay, and then, well, there was the other question that was the letter, because the appellants do not have a copy of the letter from Mr. Connor. Did it reference the tree company, I think?
No, did it reference Allstate Power Vac? Did it have, because they said they're still in operation. Is there actually a truck log or a dispatch list that those trucks were coming and going? Because to the person that, according to the person that called today, you know, they've been gone for 5 years. And also the neighbors have not seen trucks there.
Okay. And I know,
which would show 2 years non-use.
Except for, as I believe town council said, the entirety of the property does not have to continue to be used as long as there are some activities still in use.
No, that would be abandonment, but you have 2 years non-use. So if it was 2 years, like Paul had given the example of a gas station, if you didn't pump gas for over 2 years, then you couldn't open up as a gas station again. Right. So if ACV didn't have trucks going back and forth for over 2 years, you all of a sudden can't have trucks going back and forth again.
Okay, and I'm going to ask you to just pause for a second, because I'm going to ask you, the board members and or town staff, my understanding was that all uses did not have to continue as long as some uses continued. And the welder is still there and something else is still there. So I see nodding of heads, but nodding of heads are
yes.
So Mark, I'm going to ask Mark Rattan. I'm sorry, a different voice.
I guess 2 things that stick out to me is, One is the company is insisting, the official from the company is insisting that they have continued use of the property. And in fact, he sent photos to say consistently there have been trucks on the property. Don't know whether they're his trucks. Don't know if he's doctoring the photos. I mean, there's all sorts of possibilities that are beyond the scope of our investigation here. But he's saying that they have continuous use. And as the building inspectors pointed out, the welder and others have been using the property consistently. So I don't see that you can say the property has been abandoned, or at least, you know, I can see that there probably were times when there were no trucks there, but were they no trucks there for 2 years? Was there no use of the property for 2 years? You know, at this point, I don't see the case, especially with the owner saying, no, we have continually used it, and here are the Google Maps to say, you know, as I say, they've made an effort to give proof that they have been using the property.
Right. Thank you, Mark. Anyone else have a similar? Jeff?
I'll just, if you can hear me, I agree. And it's a use issue, which is before us, as you said, Madam Chair. And then there's an enforcement issue that is an ongoing thing that's been difficult for the abutters. And I think that needs to continue. But the issue before us is about this continued use. And they've, just as Mark said, the official of the company has demonstrated that they did not abandon the property and they had some use continuing. I think that's what's before the board right now.
Okay. Dick?
I just wanted to say, I have an office at 386 West Main Street, across the street, about 200 yards up from there. And I drive by this location probably 5 to 10 times a day since 2002. And I've never had the impression that it was abandoned or not in use. There's always been, you know, vehicles at the main office. The welder has always been there since the late 80s or before. So I think it's been consistently used.
Okay, thank you. Okay, I do want to just be respectful of the fact that there are people in the audience that had their hands raised. I want to give the Leonards a chance to speak related to whether they have any evidence or information on the non-use or that the use is not contractors' yards. And I think you just have to unmute yourself because you're already in our little box. There you are.
Hi. Can you hear me?
Yes.
Hi. I do have a statement I'd like to read, please. And it is pertinent to some of these things that we have discussed so far, obviously.
Okay. And can you just state your name because somebody's going to be doing minutes? I'm sorry.
Yes, no problem. My name is Chihei Kwan Leonard, and I live at 5 Buck Hill Road.
Thank you.
I'm also authorized to speak on behalf of my neighbors Ed and Andrea Hardy of 9 Buck Hill Road, and we are both direct abutters to this property. And I'd like to summarize the letter from my attorney, Mark Lanza, to have this added to the record. The letter starts out by stating, describing the 3 properties which are just situated at the Business West zoning district, formerly Business B. All 3 properties are entirely within the overlay of Area 3 of the Groundwater Protection Overlay District. The GPOD provisions of the bylaws are in the nature of environmental protection regulations. They place additional limits on activities on land in the GPOD to protect the town's water resources. They do not allow uses which are not permitted in the underlying zoning districts. Section 70710 paragraph D number 3 says, required that uses allowed by special permit in Area 3 of the GOPD must conform to provisions of the underlying zoning district. In 1987, a contractor's yard was allowed as a matter of right in the Business B zoning district. In order for the contractor's yard to be conducted as part of ZECO's business, a groundwater protection overlay district special permit was required. Therefore, except for the GPOD special permit, No zoning relief was then required to operate a contractor's yard on land in the Business B zoning district. In July 1987, the ZBA issued ZECO a special permit pursuant to the GPOD provisions of the town's zoning bylaws for the construction, operation, and maintenance of offices, garage, and yard as a contractor at 329, subject to certain conditions. It's important to note that among the conditions was a limitation, condition number 2, on the inclusion of 333 as part of the project area for the purposes of providing land area to meet lot coverage requirements and a septic system and drainage retention area only, and not for the operation of a contractor's yard. An amendment to the bylaws in 2009 made a contractor's yard use in the Business B, but now Business West, an amendment, Business West zoning district, a prohibited use. By virtue of this change, any use of 329 as a contractor's yard then became non-conforming. On or about 2017, any such use of the property had ceased and was not recommenced within 2 years. Under section 708050 of the bylaws, a non-conforming use or structure that has not been used for a period of 2 or more years shall lose its protected status and be subject to all of the provisions of this bylaw. By operation of this provision, any protected status of 329 as a contractor's yard was lost. Pursuant to the clear and unambiguous language of section 70710, paragraph D3, the GPOD special permit alone cannot give a contractor's yard use at 329 protected status. So since the zoning enforcement officer's determination that there's a grandfathered contractor's yard use at all 3 lots is based on the assumption that the 1987 GPOD special permit allows the use on them, and his determination that the use has not been discontinued for 2 years or more, his decision is erroneous and must be reversed by the ZBA. I agree with these statements, and I'd like to point out that the 1989 Board of Health letter that stated ZECO could not park his trucks on the site. They needed to be parked on 345 West Main Street due to the possible residue in the trucks. The new owner should also not be allowed to store vacuum rental trucks on this groundwater 3 overlay site because the vacuum truck rental is not an allowed use in Business West, and the use is a danger to the town groundwater and the wells in our neighborhood. I would ask you all to vote to uphold the appeal and reverse the zoning enforcement officer's determination. I'd like to thank all of you for all the time that you've put into this.
Thank you very much, Ms. Leonard. Okay, I do see that there are people with their hands up. I'm going to ask, as I call you in, to specifically speak to whether you have information that would say that the use of the entire property has not been consistent, not the gravel being used for a parking lot, because that's an enforcement issue, not a use issue, and whether the two, yeah, okay, I'm going to start. All right, Mr. Lanza, you still have your hand up. I don't know whether you are actually able to talk or not, so I'll give it a shot. It's still, nope, there you go. Okay, Mr. Creamer.
Hi, good afternoon or good evening at this point. Just a couple quick things. My name is Michael Creamer. I am at 1 Buck Hill Road. Just a couple quick things here is first, I really appreciate the board's time in hearing this appeal and all the ins and outs that come with it, especially trying to fit the 1987 round hole into the 2020 square peg that it is. So first, thank you for trying to do that. And secondly, it appears to me that we have a little bit of a gap here on the board understanding exactly who's where, what company is operating at what particular point in time and what they're doing, who owns what. So I would implore the board to kind of maybe take a step in the future to figure out how to close that gap. And secondly, my other point goes to what Mr. Blanchett had mentioned. 2020 is very different from 1987. So I'd also ask the board for a future discussion here is, what does 2020 look like for the board? as opposed to 1987? And how does the board look to change some of those bylaws that we have out there for the zoning district to be more in line with what we would expect for businesses in 2020? And third and lastly, just Mr. Federico and the zoning officer enforcement, I would ask you to, whichever way that this decision goes, to maybe take and ramp up your enforcement some way, somehow on this property, both for the trucks and the noise that goes out there. They seem to be out there 5:30 a.m. on a Saturday, 9:30 at night on a Tuesday. I don't think that is in line with what's expected at this property either. So I'd implore you to take another ramp up of what's going on out there in the first place.
Thank you, Mr. Creamer. Okay, Mr. Hanson.
Hi, yes, my name's Eric Hansen, 6 Buck Hill Road. I don't know if you can hear me.
We can.
Okay, excellent. Yeah, I wanted to speak to some of those same things and specifically about one thing, the enforcement of the property. If we've known that they haven't been maybe in violation and there have been enforcement action against them, that we could do more to enforce that. But more importantly, I wanted to address the idea of ACV. It's being as an industrial waste company, and it's operating under the idea of a construction yard, which clearly it's not. It's a different type of use. Now, in 1987, that might have been relevant and fine. However, what you're talking about now is a company that's an industrial use company. And the tree company and other ones there are now trying to slide in the use of a construction yard, which I don't believe can be just transferred from ACV to a different company, especially since it is substantially different in operation. And I thought that you had to have the transfer for non-conforming use, that it wasn't in perpetuity. It has to meet certain standards, and that this company, or the company, this tree company specifically, is significantly different than an industrial waste company, which really doesn't fall under contractor's yard. And Mr. Federico then tried to reference the idea, well, the welding company's been there forever, and I don't contest that at all. But the welding company was, it also does not fall under contractor's yard, my understanding. When it's listed underneath in the bylaws, contractor's yard doesn't say welding company. So although I'm not arguing the welding company, again, we have two companies, one industrial waste, one welding, neither truly contractor's yard, and the companies that are trying to operate there now want to go under this contractor's yard determination, which, if we're talking about passing non-conforming use on, it should meet the same standards as the companies that are using the lot now, which is industrial use and welding. But the companies that are going to go in there are not meeting those. They want to now just go on contractor's yard because it was a broad definition in 1987. So I was hoping that maybe Mr. Federico could clarify the definition of a contractor's yard, but also maybe talk a little bit about, Mr. Federico, your interpretation of significantly different businesses and how that passing is allowed, because my understanding is not in perpetuity. It has to meet certain standards. And I believe there are some things called the Powers test. And I wanted to see if Mr. Federico could speak to those as well and how he made this determination. Thank you.
Okay, so Mr. Hanson, I'm not going to, we did read the actual definition in the bylaws of what a contractor yard is, and you're right, it's broad, and I think intentionally so. But there is no variance or being sought, so there is no perpetuity. This is a use of the 329 as a contractor's yard, not the individual tenants within it, and whether or not that contractor's yard is still being used. But Bob, I don't know whether you have anything you want to clarify, but in addition to the definition as it was read?
Yeah, I'll add a little bit more to it. One of the conditions that is in the zoning bylaws is that if a special permit is granted, the conditions on that special permit are to be upheld in perpetuity. Okay. So, you know, the tight tank, it was replaced. It's in violation. They were putting a new one in as we speak, I believe. Again, the enforcement of the gravel driveway. I don't have the regulations from 1987. People have to remember that this whole thing broke with that special permit in 1987, and that sets the guidelines for the definition of contractor's yard, the activity that goes on it. We've said before that it's not who is on the property, but it's the strict use that's on the property. And it varies from in degree and in scope. And the definition of a contractor's yard is vague, I will admit that. But what I've found is that, you know, for what they're doing, I don't have a reason to not allow it. That's hence the appeal. So.
Fran, turn your mic. Turn your mic, Fran.
Sorry. Thank you very much, Paul. Okay, the members of the board, do you have any additional questions or concerns that you need to have addressed as we move forward tonight on this appeal?
I have one,
Sure.
and I think one of the neighbors brought it up in terms of the grandfathering of the use, and sort of how wide of a band, you know, we would think about, you know, contractor's yard, as Fran said, is very broad use, right? But how far along that broad use can you go? Meaning, you know, so the welder's there, he's been there for forever, right? But if he's considered a contractor's yard, right? That doesn't mean that, you know, he's grandfathered and the welding is grandfathered, but that doesn't mean that you can maybe just start storing lumber or trucks and everything else, right? Just because you have one person on one piece of the property that's being used. And my understanding generally of the grandfathered use is that it's typically never an expansion of the use. So going back to my original gas station, I guess, example, and that is you have a gas station that's there, it's been there for forever. They can't say it's a grandfathered use and now put in more tanks or, you know, a car mechanic shop and expand the use on the property. Is that is accurate sort of thought process in sort of the grandfathering and sort of how the town or we view that, where it's, you know, saying it's grandfathered use, so welder to welder to welder to welder throughout time, right? But welder can't be a welder plus a lumber yard plus a, you know, a vacuum truck or some sort of an expansion, right? Right. I guess is my question.
Right, but I guess what's in front of us is a contractor's yard, which has many components, not just welding. But I think that's certainly something that will have to be deliberated when eventually we close the hearing and we move to the next step, right? But in the meantime, does anybody have any specific information that they feel they need in order to get to the next step of deliberation and decision? Okay. Well, I think we've had ample opportunity for public comment. If
Madam Chair, I'd like to make a motion to close this hearing.
Thank you, Brad. Do I hear a second?
Wait, we have something from our.
Oh, I'm sorry, Bob.
Oh, sorry, Bob.
Sorry about that. Kind of a procedural question, because I'm involved with the appeal, and when you folks go to deliberate, I'm assuming that I will not, and I'm not planning on saying anything while you deliberate.
Correct.
Having said that, I've got a couple of questions and a couple of requests, okay?
Okay.
Should the committee grant the appeal to the appellates, okay? We are all going to be in very uncharted territory in terms of who do we throw out and how long it's going to take and who's going to write that order. Okay. That is something that I will admit is way beyond my wheelhouse, and it's going to take legal, it's going to take lots of lawyers. Secondly, we've discussed the fact that, you know, there is a statute of limitations on use that has not been, a zoning violation that has not been reported over a period of years that I'm sure will come up. We've also granted a special permit in the groundwater protection overlay district for the granite fabrication. The question would that be come into play as well. Again, the the definition for the contractor's yard is very wide, very broad, very vague. And in just about all cases, it's probably designed that way because you can't keep up with all the different nuances that are going to try to come into town. So my questions were, if you decide to go with the side of the appellates, who's going to do the throwing out? How long is it going to take? And who's going to write the orders? Okay.
Yep.
That's about all I have to say.
All right, thank you. And then when we do get to this point of the discussion, if you wanted to leave the room, you certainly are welcome to do that.
Sure.
Okay, so those points taken. Those points taken. I have a motion.
I'll second the motion to close.
Okay, so I have a motion from Brad to close the hearing and Mark Rattan to second. Do a roll call vote. Brad?
Aye.
Paul? I'm sorry, Mark?
Aye.
Paul?
Aye.
Dick?
Aye.
And Fran, aye. Okay, so the hearing is closed. We will deliberate and discuss and hopefully come to a decision later this evening. Thank you all very much. I want to go to moving along just real quickly to Kathy, can you tell me what is the date of our next meeting?
November 24th.
November 24th. Okay, we have a request for a continuance for 50 Southwest Cutoff to our November 24th meeting for expeditious purposes. Does anybody have any concerns, or Kathy, do we need to know their reason for, please?
Well, they're presently still working with the design review committee, and they want to finish out with the design review committee before they come to you.
Okay, thank you.
Okay.
Okay.
Chair,
Yes, Mark.
I move that we continue the 50 Southwest cutoff to our November 24th meeting. Are we doing this at 6?
Yeah. Yes, I would say so. Yeah.
Okay.
Okay, I hear a motion.
Second.
And
Brad
Brad
seconds.
is the second. Okay, so we have a motion by Mark and a second by Brad to continue 50 Southwest Cutoff to our, I didn't read the whole thing. I apologize for the continuation. On a roll call, Brad,
Aye.
Mark,
Aye.
Paul,
Aye.
Dick,
Aye.
and Fran, aye. Okay, so 50 Southwest Cutoff is continuing to the November 24th. Give me one more second. I was trying to do two things at the same time. Okay. All right, so that's that. Okay, so now we're going to bounce back up to consider the petition of NB Real Estate LLC for the variance special permit with site plan approval, special permit groundwater protection overlay district to allow partial demolition of the existing building and to replace it with a new building that will be approximately in the existing footprint on the property located at 56 Hudson Street, map 54, parcel 84 in the downtown neighborhood district and groundwater protection overlay district area 3. Just give me 1 second to put this on the floor. And then tell me who is in the audience that will want to speak with us on this.
We actually should have, and I know I think Becca has the list too, but the Matt Pizzani is from 56 Hudson. He's with Maytech. And then there's also Randy Waterman. I believe it's Randy tonight. Oops.
I'm trying to find any of those
Okay,
names.
you're on mute.
Oh,
Fred.
there's, no, I'm not. Okay, I see.
No, Fred is.
Okay, I see.
He was
Is Matt
talking. Sorry.
Pisani?
Hey, Fran.
Yes.
Yeah, Matt Pisani.
Okay, all right, Matt's
Person
in.
listed as WDA-DG is Randy Waterman. Should be.
WDA, okay, I've got Randy in. So I have a Randy and a Matt. Do either of you gentlemen know that whether somebody else I should be adding in?
Tom Reardon was going to show up,
Oh,
but
I see him. Nope, he's here.
Okay.
Hey, Tom. Okay, okay. So there's three of you, Matt, Randy, and Tom.
Yes, hi, this is Randy Waterman. I am here.
Okay, and who's going to be speaking first on behalf of the application?
I can do that if you like.
Okay,
This is
Randy. Okay. All right. Go ahead. The floor is yours.
Okay. Good evening. So again, the project that we are here to discuss tonight is a demolition of a portion of the building that is at 56 Hudson Street in Northborough. Most of you, I'm sure, probably know this building. Maytech has occupied the building for 20 or 30 years. The building currently is at the location where Cold Harbor Brook crosses under Hudson Street in the southerly direction, and that forms the lot line for this part of the building. And then it connects with the Assabet River, which then runs in an easterly direction along Hudson Street. The property is currently in a downtown neighborhood district. It was rezoned from an industrial IB district in 2009. The property is in the Groundway Overlay District 3, and it's also in a floodplain overlay district. The property is a total of about 1.7 acres, and it has around 296 feet of frontage on Hudson Street. So the proposed project is essentially to take the westerly half of the building that parallels Hudson Street, and that's the part as you drive by that is currently covered in blue metal siding, and demolish that portion of the building that is about 175 feet long by 40 feet wide. And that building currently is a two-story structure. And the proposal is to rebuild on that same footprint with a three-story structure that would be more efficient for the employees and for all the rooms that they work in, break rooms and so forth, that they don't currently have. So the proposal is really to build that roughly 7,000 square feet of the building on the same concrete footprint, with the exception of one little bump out in the back south side of the building that would connect to the adjacent existing building on the property. And that section of building overhang essentially is about 10 feet wide by 100 feet long. And that would connect the separate building on the site to this 56 Hudson, so they become one building at that point. There's no new parking proposed on the site. There's no impervious surface, no tree removal. Essentially, like I say, the majority of the building is to be remove this half of the building and replace it in kind on the same footprint. There are no new employees planned for the site, and there's no new parking proposed on the property. This is really just to make the building much, much more efficient. There is an existing loading dock up in the northwest corner of the property that is facing Hudson Street. And that loading dock, obviously right now is not in a great situation. It is turned 90 degrees from the building. So it faces directly onto Hudson Street. So as trucks come down here, these are the smaller delivery trucks, the 20, 25-foot box trucks. They need to turn and cross Hudson Street now and back directly up to the building. So they're turned at 90 degrees to the street, which is not a great situation. So the proposal is, as shown on these plans, is to turn that loading dock so it's roughly at 45 degrees from the existing building. So it's no longer 90 degrees to the street, but closer to 45 to the street. And that way trucks could pull up and stay in their own lane instead of crossing both lanes and back directly straight up to that loading dock. So it's not obviously the perfect situation, but it does, we believe, improves the safety that is, happens with the trucks that back into that site. By doing that change and swinging that dock so it's a little bit more at a 45 than a 90 to the building, that pushes that corner of the building slightly more closer to Hudson Street. So the existing setback to Hudson Street is 15 feet for that front yard. And they are currently, the building today is about 8.5 feet off. So it's non-conforming today. And with this change, the building would be between 8 feet 2 inches to, or 8.2 feet to 7.2 feet. So there's a couple places in that corner of that loading dock where it becomes just slightly closer and more non-conforming than it is today. But the whole purpose is to correct as best they can that loading dock situation. So other than that, there's really no increase in impervious or any other structures on site. We have been through review by the Design Review Board and the Groundwater Advisory Board. And I think you received Fred's letter today that I think we've provided the information to the Groundwater Board that they've been looking for. There's no increase in impervious other than I say that, you know, one stretch of the building roof that's 10 feet by 100 feet wide, 1,000 square feet total. We are proposing a new rain garden on site to help offset some of the runoff that comes from the roof of the building at 56 that remains on site. And that will provide some additional polishing to the surface water on site that doesn't currently happen. So that has been, plans have been provided and drainage calculations have been provided to Fred's office for that improvement. And essentially we're here, let's see, for the special permit for the groundwater work, the floodplain, site plan approval, and that variance that I mentioned for the slight increase in or decrease in the setback from Hudson Street for that loading dock change. Matt Pisani is here also from Maytech. He's been working closely with us on providing all the information to Fred's office, and Tom Reardon is here as the architect for the building.
Okay, Mr. Pisani or Mr. Reardon, do you have anything you'd like to add at this point?
I do. There was one other variance I'd sent to Kathy a little late. I got it to her yesterday, where along the north side for Hudson Street, we are looking to increase the roof line from 2, which the bylaw says 2 feet. We're looking for 3 feet. But other than that, I think Randy said all the project is.
Okay, thank you. Kathy?
Could I also mention that this is Tom Reardon?
Sure.
There's going to be a 10.5-foot space between the existing brick building and the new addition. So we are reducing the footprint in that area, 10 feet by 40 feet. And also we pulled away from Cold Harbor Brook by about 10 or 15 feet to square up with the existing assembly building. So that's how it remained almost identical. We increased a little bit on the south side, but then we removed some additional area.
All right. Thank you, Mr. Reardon. Kathy, can I ask you to elaborate on I added a variance just yesterday? I don't understand that.
Yeah, I'll, Matt or Tom, if you can just, I mean, as the applicant, they should explain that. But Tom, maybe you can explain that a little bit more. It just
Sure.
has to do with the roof overhang.
Right. There's a limit of 2 feet roof overhang by right. We're proposing to go to 3 feet along Hudson Street for the main roof. And then there's a small upper roof over the stair and elevator that's also would be 3 feet. Everything else would be 2 feet or less.
Okay. And I mean, I'm not an architect, but what's the reason for that?
Well, it helps the shading of the office area on the upper floors.
Okay.
And gives us a little more ability to break up the length of this building.
Okay.
Give it some more detail.
All right. Does that extra foot on the roof line affect the setbacks? Or are you still within the setbacks?
Well, the building is already non-conforming.
Oh, true. Okay. 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 Board members, questions? Mark?
Yeah, as far as that set, we're already up at 2 stories or several stories with this 2 feet versus 3 feet business. So it's.
Well, if I can answer that, the existing building is predominantly 2-story with one section near Cold Harbor Brook that is 3 stories. Maybe a third of the building is 3 stories. The first level is 4 to 5 feet below grade. So it's like a half story.
Right.
And then we're going to have 3 full floors.
Right, but I mean, this overhang is we're talking this is up 2.5 stories in the air.
Yeah, it's 30 feet above grade, correct.
Okay.
Other questions from the board?
Madam
Brad?
Chair? Yeah, so you mentioned it's going to be more efficient. Can you please elaborate on how this proposal will be more efficient, whether it's environmentally, energy-wise, etc.?
I can address that. Right now, we are working basically out of 3 individual buildings. So our production moves from building to building, which we do, but it makes it a little difficult. It's really not effective. So what we're trying to do is on the new building, tie it into our main production facility. So the ground floor will be one contiguous space where we can build systems. Maytech builds non-destructive ultrasonic testing equipment. We don't build a model, we build to our customer specifications. So very few are similar. So it's a live floor. And what we do is we build the system up here. The customer comes in, checks it out, like it, don't like it, change this, change that, and then we ship it out. And now that floor space is available for the next system. So it's not like we have truly designated areas for system A here, system B here. It's a live floor. So to have it on one continuous floor would help us dramatically in terms of production moving forward. And then, you know, where we are in this building here, which is designated the office space, the new facility would allow us to be spread out and more functional, where we can have engineering in one office instead of on multiple levels where we have them here. It would just have a nice flow for us, and flow means production.
Thank you.
Okay. Thank you.
Okay. I have a question. We did get something from the town engineer related to the Groundwater Advisory Committee and their recommendations. And I guess, I mean, I'm jumping right. I know you said you received it, but if I could, Fred, the last one says that there is concern about the location of the loading dock and the length of certain trucks. You can recommend a proposed loading dock, but has one discussed as to where that would fit, and would there be revised plans needed if they could?
Well, thanks for giving me the opportunity to explain that one.
Okay.
That comment comes from planning, from engineering and the DPW. Our main concern is the blockage of the sidewalk and the crosswalk. I understand there is a 90-degree dock there today, and that they are trying to make an improvement. Our feeling is that if the truck is any more than 24 feet long, then it reaches to the sidewalk and inhibits people from walking along the sidewalk without going into the street. And my suggestion is that perhaps there's someplace else along another side of the building where that loading dock could be relocated. I had raised the question back in the beginning when the project was first submitted in an email to the applicant when they were first trying to get before the groundwater committee, but there's been no real response. So I took the opportunity to add it to this letter so that we could have a discussion tonight.
Okay, thank you. And just, do you normally have trucks longer than 24 feet going to your loading docks?
We because of the position of it right now, where it is truly 90 degrees to the road, and when you come down River Street, it's a blind corner. So we don't use it as much as we would like to because of the danger it is right now. The proposed dock would not, because of the height, it wouldn't be for trailer trucks because it's a little too low for trailer trucks. The idea there is more for the FedExes and the UPSs, where it's basically a live unload, where they can pull up, unload the packages and go. And so a typical, like a cargo van type building. No trailer truck would be backing up there because of just the inconsistency of the height. It would not be ergonomically possible. They would still go on our main driveway, which is accessed off River Street, where we could unload them there.
Okay, thank you. Is that satisfactory answer, Fred?
Yeah, it's getting there. I think that if the board wanted to approve that loading dock in its current location and arrangement, I'm not crazy about the fact that the truck has to stop on Hudson Street and back up in order to get off the road. We typically don't recommend, we don't allow people to back out of a parking lot onto a street. We don't recommend that they back up along the street to get into the driveway either. If there's no other place, if there's no other way for them to unload the trucks to service their building, then perhaps a restriction on the truck's size using that door might be appropriate.
Can I make a comment?
Mr. Reardon?
Approximately a year ago, we had an informal meeting with members of the town staff, which included the fire chief and chief of police, and they gave us 100% approval for this rearrangement because it was such a safer approach for this loading dock. So with that positive response, we continued on with our reconfiguration as we're showing it in our drawings. But if you look at the footprint of the proposed reconstruction, there are very few locations where we could actually put a loading dock. We have another assembly building that is 10 feet away on the Assabet River side. We have an alleyway that has a set of stairs, so that's out. So really the best location for this lightly used loading dock is on Hudson Street. And I'm not sure that that would be much of an impediment to pedestrians because I hardly see anybody walking along Hudson Street these days. I could be wrong on that, but.
Well, I'm just going to throw out the fact that we didn't build a sidewalk because nobody will use it. So
yeah,
we're hoping that they use it.
Right.
Madam Chair, I just want, where is this loading dock located? Is it on Hudson Street? Sorry.
Yes, it's up in the northwest corner of Hudson Street and right touching the corner of the building, up as far upper left corner as you can go.
But it's really on River Street.
No,
it's on Hudson.
I walk by it every night. I can't understand.
Go to the proposed site plan drawing.
Yeah.
Yep.
That's exists.
It's right. If you were, this isn't technical, but you know, if you were standing in Hudson Street looking at the building, it's almost as far right as you can go on the building.
Far right.
It doesn't. You probably don't even recognize it as a loading dock because it's level with the street. And there's one loading dock door on the side on that building. So it's on the front of the building.
I never even saw it.
If you walk down Hudson Street and you see the crosswalk,
yep,
right there.
Yep.
Right. Yeah, that's another way to find it.
Really?
It's on sheet 2 of our drawings.
Oh, okay. But you're taking down that piece of building and making a loading dock there. Because right now the building's right up to the curb.
But the loading dock is there and used today.
I feel like going to tell my husband that we walk by it every single day, and I've never seen anything that looks like that.
The loading dock is on the face of the building now, and they're proposing to have a loading dock that extends out and turns 45 degrees. So if you go to sheet 2 of our drawings, that upper left-hand corner, you can see the angle of the loading dock, the way it's shaded on the plan.
Yeah.
And again, the idea is today, if a box truck comes to this site to pull into the loading dock that sticks out, that's 90 degrees to the building, he has to turn and cross both lanes of Hudson Street and back across the street into the loading dock.
Right.
And the hope is that if they can at least turn it 45 degrees, that person would come along and stay in his own lane on Hudson Street and could turn slightly into this angled loading dock. And you can see that on sheet 2, it's shaded, that the angle of the loading dock is shaded on there. So he wouldn't need to cross both lanes of traffic, certainly. So it definitely would be a better condition. It'd be great if they didn't have to go at all on Hudson Street, but that's not really an option.
Okay, and if it was to be a condition that it could only be trucks of a certain length, that would be an agreeable condition?
It would, because I mean, it's really not feasible to have a trailer truck there. So it would be only for the FedEx's, UPS's, smaller box truck, cargo van type deal.
Okay. Brad, you had your hand up?
Yeah, Madam Chair. So I'm not making a motion here to continue, but I would feel a little more comfortable if we were able to continue. We can obviously gather more information tonight, but just to get a walkthrough, because we're just kind of like, where is it? Where is this going? How are things going here? Hudson Street's a main road. And I just don't want us to approve anything without having a full visual of what exactly is happening here. I mean, I have the documentation here, but I personally would feel a little more comfortable just having a quick walkthrough, personally.
Okay, all right, how do other members feel? Certainly take advantage of questions at this moment from people.
Madam Chair, I mean, I guess I would probably be interested in a walkthrough as well, just to kind of get a better feel for the project, given all of the different variances that do need approval. I guess maybe I'm not getting the full grasp of everything, but you know, it would be nice to just take a kind of walkthrough.
So, Paul, if I could, or Fran, so a walkthrough as in you want to go into the building too?
Well,
I mean, we can definitely arrange
perimeter.
that.
I mean, perimeter.
Or is it just,
perimeter.
or is it
But
just
whatever.
for you to go, you know, for you guys to go over there, walk around, and get a visual on the outside?
Yeah, it's like, where's the loading dock exactly going to be? Where's the truck going to back in? Like things like that.
Yeah, it's hard for me. Again, I mean, we do literally walk down that sidewalk and cross that crosswalk and look at the fake stalk that's in the Cold Harbor on the other side of the street and go, look, he's still standing there, even though he's not eating because it's not real. I see that every night, but I cannot visualize where there could fathom a loading dock. So yeah, just, you know, something that with chalk lines on the outside to give us a sense of what's happening. I think that I would appreciate that.
It's 2 gray double doors. You can't miss it. It's 2 gray double doors right in the side of the blue. So you'll know it right off the bat.
Okay.
I have photographs of this. Is there any way I could hold something up to be seen?
Sure.
I don't know.
We need to get you in as a presenter. So that's is it Becca? Becca, can you hear me?
Yes, Mr. Reardon should be able to share his screen.
Okay, so Tom, you can share your screen if you have them on your computer versus in your hand. I'm assuming he's trying. And while he's trying that, everybody does have the 15-point letter from the Groundwater Advisory Committee through our town engineer. That is pretty comprehensive.
And if I
Yes.
could also point out too that you don't have a specific letter from the Design Review Committee because in this particular case, the Design Review Committee, you know, did meet with the applicant a couple different times, and everything was incorporated into the plan. So the plans that, as presented, you know, take into account what the Design Review Committee discussed with the applicant, and it was pretty straightforward. Everything was an improvement over the blue.
Okay. All right,
metal
there you
building.
go, Tom. We see your screen.
So the picture in the middle, if everyone, I know Tom's going to get
I'd
to
want
it,
to
but
see. Yeah,
do
I'd
you
want to see where he is right now. It's, you know. So we'll give.
So
You're probably
I
still
clicked-
muted. Okay.
Can you see the 2 photos?
Yeah,
can see
but
a bunch.
everything is on the screen, Tom.
Oh, how do I?
I think
try
if you
clicking on
double
them.
click,
Double click
Okay.
on that
I
one.
highlight them and do what?
I think if
No,
you just
double-
double clicked on it.
Double click on 'em.
There you go. Okay.
All right, so that, can you see my cursor?
Yes.
That's the loading dock door.
Okay.
It's a double door. There's a bump out that's going to be removed.
Okay.
And there's the crosswalk.
Mm-hmm.
And the sidewalk ends right at the end of the blue building.
Okay.
So what we're proposing is where the single door is, we're going to come out at about a 45 degree. So you'd back in along the street rather than perpendicular to the building.
Okay. I can see why no one uses it right now.
That, can you see that?
Yes.
That's the existing loading dock. So that's about the level of the second floor. So it's ideally set up in terms of floor elevation.
Okay. And that would be the same height at its 45 degree alternative.
Correct. And it produces a paved driveway that's on the short end is about 24, 25 feet long, and on the long end it's about 35 feet.
All right. Can you do the picture again that shows the down the road? Either
or another one?
No, I mean up to other members. Where the Cold Harbor runs under the building, that's further south.
It's down here.
Okay.
Down near the brick building.
Yeah.
The one-story brick building is not on Matex property.
Okay.
That's on the opposite side of Cold Harbor Brook.
Right.
So the Cold Harbor goes underneath this panel.
Okay.
This blue panel. And this section is being demolished, and we're moving the building away from Cold Harbor Brook by about 10 or 12 feet.
Okay. And how close will the backup area for the loading dock be to Cold Harbor?
Well, the back of the building at the most extreme is probably 10 to 15 feet away from the brook.
Yeah, it'd be 20 feet by
20
scale
feet?
off the plan.
Okay.
Just over, maybe 23 feet.
So, okay, so a truck would drive into that property, come up right up against the Cold Harbor with something to block them from going in, and then back up to the building?
Well, there'd be a section of the building that you'd be backing up to.
Right, but what's in front of you? What's at the front of the truck as you're backing up? Open space?
The loading dock itself will be, you'll be backing up to that section of the building.
Tom, would you say the window would be a good, use the window as the new loading dock?
Right, correct.
Just for a landmark?
Yep.
Yeah, or a little bit forward of it.
Right. So instead of the double doors perpendicular to Hudson Street, it's more at a 45, trying to go more parallel to Hudson Street.
Okay. I see parallel. I don't see 45 degree, but
Where the loading dock is right now,
Yeah.
for a truck
Yeah.
to back up there, they have to virtually shut off the one lane of Hudson Street.
okay, what do
If I
people
might,
think?
Ken?
Yes, Mark.
What they would curve the building so that rather than that gray loading dock facing straight onto Hudson, it would go more toward us in the perspective of this picture. So that as I see it, the truck would come down Hudson toward us in this picture and then back straight toward that gray door, but that whole side of the building would be rotated 45 degrees. So they'd be going
It's not even
straight
45.
flat into the new loading dock.
Okay.
Does that make sense?
Yes.
Just how far is it from the loading dock to the street again?
About 8.5 feet at the outermost corner.
Today.
we're going to try to match that. We don't want to go into the setback more than the existing building. That piece you see right here is about 8.5 feet from the property line.
No, I mean, so today, that door, where the loading dock is, from that door to the edge of the street is how big?
I think it's 15. Is it 15?
15?
Hey, Tom, is that to the street or to the property line?
Property line.
Is the property line, do you know if the property line includes the sidewalk?
It's not supposed to.
Nope.
Well, according to this, Randy's sheet number 2, at this corner here, the curb and the property line are almost identical.
Yeah, they're pretty close to the edge of the curb. So the sidewalk out there is about 7 feet off of the property line. And the building itself is about 15 feet off the property line.
I know that the design review committee, had the building elevations. Obviously, that's what their purview is mainly. But would that help if I sent you all the elevations so that you could take a look at, it would give you a better visual?
For me, it really is the idea that this is very close and very sensitive to not wetlands, but floodplain, right? To an actual river. And I know that the river currently goes under the building because we've walked around it. I'm having a real hard time understanding how a even perpendicular loading dock that's going to be 8 feet from the road versus a perpendicular 15 feet from the road is, it sounds like it's better, but whether it's, not still too, unsafe for it to be granted a variance or special permit. I really don't think that this is enough for me, but I'll defer to the other members.
Madam Chair, I guess for me, I still would like to have more information. And I think the best way for me would be to sort of get a outside look at what the changes are, just to understand exactly, the 8 feet, 15 with the sidewalk, like what does that actually mean? For me, for right now, I think that I would probably lean towards, I'm not making a motion, but continuing and then going to take a closer look and then coming back next meeting. I guess that's where I'm leaning towards right now.
All right, Dick or Mark, I know that Brad had already said that he was interested. I know we've seen pictures. I don't know, Brad, if you still feel the same way, but I'd like to also hear from Mark and Dick on what they think.
Sure, yeah,
I
Mark
would
and
like
Dick,
to-
go ahead. I'll wait.
I would like to continue this until the next meeting so that we can go out and have a site visit and understand what we're doing here.
Okay, thank you.
I would agree.
And do you want me, I just want to make sure that I follow up properly. Do you want to meet Tom and Mark out on the site, and you can do it as a group, or you all just want to, drive down there, between now and the next meeting, just so that you've get a, personally a better understanding, or because we can easily set something up if you would like to.
Is there any problem with this being, quote, a non-public meeting? I imagine if we go there, we meet them, and we're together as a group, we're going to ask questions.
Well, no, you can't ask questions, but you can, I mean, you can you can have a site visit, and that's perfectly legitimate for a board to do that. You just can't exchange, have questions and then have those answered without the public being there, because it's, the public should be able to hear whatever kind of exchange you have. So it's very similar to when you went out and looked at Rice Ave with the dog proposal. You all walked around, you got it explained to you, but you didn't discuss anything on the site. But if we had the architect and Matt from Maytech there, they can explain to you. That's perfectly, within the scope of a site visit.
And I would think that we could also, given the times that we're in, pick a time frame and do it in either individually or smaller. I mean, it's not, I'm not interested in walking through the building or any of the, that structure. It's really about the loading dock and how it encroaches into the floodplain, and the fact that this is a neighborhood, downtown neighborhood, that we're trying not to make it too industrial-like, but I'm going to put my faith in the design review and Tom Reardon's other previous works to know that it's going to look good. I just need to make sure that it is safe in how it's not just looking good, but it's safe as well. But so just a walk. This is the piece of the building that's going away. Here's where the loading dock's going to be, and here's where the brook still is, and no truck is going to tip into it when they back up.
Okay.
I would agree with that. I don't think I need to really see the inside, just an outdoor visual.
I agree.
Socially distant.
I agree.
Masks, wear masks. Yep. Wear your masks, everybody.
Kathy, do you want to set a time that we can do that so we can make sure we are in attendance?
Sure. Why don't I send out an email over the next couple of days? Get some dates and times from the members.
Okay.
And obviously the sun is setting earlier, so it would have to be something during the day after 7:15 in the morning and before probably 5:15 at night.
Earlier than that, Fran. 4:30 sunset will be set in a few weeks.
That changes on Saturday.
Yeah.
Oh, it's even worse. Okay, well
Yeah.
then let's do it early in the morning. So, all right. So, do people have other questions? Because I don't want to leave this open-ended without, and then leave them hanging for the next meeting. I know that, gentlemen, you would have received the conditions of the Groundwater Advisory Committee. Other than number 15, did you have any concerns or issues with what was required?
No, I think all those conditions have been agreed to at the last hearing, and I think we provided most of that documentation. So yeah, those are consistent with what we've talked to Fred about at some length. Yes.
Okay. All right.
Yeah,
And
I would agree, Fran. I've
Yeah.
worked with Matt this week and Randy on answering some of the questions in more detail that the committee had, and I think we're getting close to the cabinets and the amount that needs to be contained.
Excellent. Okay. And even though we are going to request of the applicant that we continue this to our next meeting, I do want to just give any opportunities to members in the audience that had any questions that they thought needed to be answered and or researched before the next meeting, if you would raise your hand. Okay, I see Scott Rogers. If you could just repeat your name and your address, please, Scott.
Hi, thanks, Fran. Scott Rogers at 26 Tomahawk Drive. If loading dock was in the front of the building was not approved, what
Oh, you faded out on us.
Yeah, what problem for the applicant would that be to take all loading or all deliveries from the loading dock on River Street?
I mean, it would certainly not be our first choice. I mean, but if the committee decides that it's not feasible or not safe, then obviously We would certainly like the rest of the building to be built. So we could make concessions.
Thank you, Mr. Rogers. Thank you, Matt. Okay. All right. So at this point, with the applicant's approval, do I hear a motion to continue?
Yep.
Someone?
I make a motion that we continue this to our November 24th meeting at 6 o'clock.
Second.
Okay, so I have Mark making a motion, and I think it was Paul who made the second.
All right.
Sorry. Okay, roll call. Mark.
Aye.
Paul.
Aye.
Dick.
Aye.
Brad.
Aye.
And Fran, aye. All right, thank you very much. Thank you, gentlemen. Thank you, Mr. Rogers.
Thank you for the time.
Good night.
Good night.
All right, see you next month. Okay, all right. It is still after the hour of 6 o'clock, and so we are moving on to consider the petition of Jonathan Aaliyah for a variance special permit with site plan approval, special permit groundwater protection overlay district to install an in-ground pool at 1 Blueberry Lane, map 47, parcel 80, located in the residential C zoning district and groundwater protection overlay district area 3. And I have been, it has been requested that one of our board members, Paul, I never get your last name right, Tagliaferri, has asked to recuse himself. And so I'm going to elevate Leslie Harrison to a voting member on this application. And
Actually,
Paul is
Madam
going.
Chair,
Yes.
after I apologize for not letting you know earlier, but I would also like to recuse myself from this hearing as well. Now that we have both alternates, I would like to recuse myself.
Okay.
Before you do that,
Yeah.
I also live on Hemlock Drive. Now I am around the corner, 5 or 6 houses away.
Well, recusing yourself is a person, right, is a personal
impartial on
choice.
this, but I don't, but if somebody feels that, yeah, this is a problem, I would have to jump up to recuse myself ahead of you, Brad.
Oh,
I
is
can,
Brad, are you not in that neighborhood?
I am not in that neighborhood, so
Okay.
Mark would trump me. So I
Okay.
can do it.
All right, and Jeff Leland, why are you raising your hand? It's going to be just me and Leslie and Dick?
I just want to, I think that I have less of any conflict than Mark, certainly maybe Brad, but just to identify that my sister lives around the corner. I haven't had any discussions with her,
Okay.
but I wanted to make sure that was clear.
Okay, so to recuse yourself means that you feel that you cannot be unbiased, or you feel that there would be the impression that there is a conflict. But if you believe that you would not have one, you don't have to recuse yourself. But sometimes it is more comfortable to do that. But you don't have to if you feel that you can continue without any preconceived notions.
I don't feel I'm biased. Brad, do you feel you have some dog in this fight?
I mean, yes and no. I don't know. It's like I don't live in the neighborhood. I'm not, very close with them, but I do know them, and so that's why I just.
I mean, because for me, they are around the corner.
Yeah.
I don't know them. I mean, I'm familiar with the property, but it's because I walk and run by it, drive by it. But
May I speak to?
I don't have prejudice one way or another.
Okay, Leslie?
I just want to speak to Fran's point. So when I was on the planning board, I actually did not need to recuse myself in extended involvement with one of my abutters. And it was, I was basically told the same thing, as long as you feel like you can be objective and there's no, the property owner had no problem with it. And I felt like I could continue to be objective. So I never recused myself on a pretty major, and I was a direct abutter.
Right. So I think a familiarity with the applicant probably outweighs just happen to live in the same, voting, precinct. So
Stay on.
So I would.
You don't mind, Mark?
No, not at all.
Okay.
Okay.
All right.
Thank you.
All right. And Jeff has made it us aware that there is, he is aware of somebody that lives in that area, but has not had conversation with them about that. So we are going to be a board of Mark, Dick, Jeff, Leslie, and Fran. And so Brad, if you want to just sign out, and we'll call you back when we're done. Exactly how, I'm not positive, but we'll give it our best shot.
Listen in.
Oh, I'm sorry?
You can listen in. There's
Right, yes, but
Yeah,
well,
I'll just
yes,
mute, turn off my camera,
right,
and
correct,
just pretend
perfect.
like I'm a attendee. But
There
I'm
you
not
go.
going to
Thank you
jump
so
in
much.
with any questions. Thank you very much.
All right,
Appreciate it,
thanks.
Mark. Thanks.
Okay, so now we're going to bring, we are going to bring in, hold on 1 second, I have to move my paperwork. Oh no, I feel like Brad at the last meeting. There it is.
Jonathan Aaliyah.
Yeah, all right, okay. Okay, I see you, Jonathan Aaliyah, one moment. Mr. Aaliyah, is there someone else with you on a different line, or is it just you? You're muted still. Mr. Aaliyah. Still mute. Let me see. Ask to unmute. Mr. Aaliyah, if you're still, there you are.
I'm sorry, my computer froze.
No worries. All right, is there someone else with you on another line that you wanted me to add to the meeting?
Nope, it would just be me, and I have a few items I'd like to share, so if I could present her, that would be greatly appreciated.
Okay, so first I'll just ask you to state your name and your address for the record, and then I will ask Becca, our webinar user, to elevate you to a participant, panelist.
Yep. My name is Jonathan Aaliyah, and I am the co-owner of One Blueberry Lane.
And I apologize, it's Aaliyah, not Aaliyah.
Yeah, no, it's don't trust me. I'm used to it by now. No one gets it right.
Sorry. Okay, so while she is elevating you to a panelist, she didn't acknowledge, so I don't know if, oh, there she is. Okay, thank you.
Mr. Alia, you're all set to share.
Thank you, Becca. Okay, go ahead, Miss Alia. Oh no, I hope it didn't freeze again.
Mr. Ellier is muted.
Oh, Mr. Alia, you muted again.
All right, sorry. Now, can everybody see what I have on screen right now as the plot plan?
Yep.
Okay, excellent. So thank you, everyone. I appreciate the time, and thank you those who are willing to attend and be listening on this. So my name is, as I stated, my name is Jonathan Alley. I am co-owner of the property located at One Blueberry Lane. I'm here today to present a petition to safety variance to be able to install an in-ground pool at One Blueberry Lane, which is located in the residential C zoning district. As the subject property is on the corner of Blueberry Lane and Hemlock Drive, zoning bylaws requires the pool to be 30 feet from street property line, 25 feet from the rear, and 15 feet from the side property line. Similar to ZBA case number 13-21, we are seeking a variance under 7-08-030. Variance required to install an in-ground pool on the east side yard of Affirmation property, which will be located 10 feet from the Hemlock Drive, the street property line. The reason, so as you'll see from the plot plan, as I stated, we are looking to install an in-ground pool on the east side for a variety of reasons. One, when we get into discussing the topography of the land, it will be financially cheaper to build on the east side due to the plot restrictions, as well as the number of trees that we would have to be required to take down, and additionally the need to build a retainer wall on the south side of the property, which is located in the backyard. Additionally, one of the things that we would like to do for the reason to have it on the east side is safety concerns. We want to put it away from any of the front or back or side entrances. So when you look on the plot plan of the house, the east side does not have any back or side entrances other than what's located on the south side, is that's what as you'll see from the deck. So we did want to keep it away. That way we have 2 young children. We just, the last thing we want them to do is come running right out of the back door right into the pool. So we do want to have some restrictions as far as where the pool is placed. Additionally, too, when you look at this plot plan, there is, a couple regulatory requirements happen. One being why we're here today is to request this variance because of the 2 front doors. But also, when you look at the back, the south side of it, we would also need a variance if we were to put it in the back behind here, given that it has to be 25 feet from the backyard setback. And additionally, on the left side, which is the west-hand side, if you look where we have currently right now is a shed, which I know, given it's a small enough shed, we couldn't move that. But similar to what I was just saying earlier with the restrictions, it would have to be 15 feet from this side of the property side, which is the west side. So the main reason for that, other than the ones we just talked about too, is we feel that having it on the east side, abutting the Hemlock Street, is that it's going to be least disruptive and least obtrusive to our abutters. So that is the main reason, kind of why we're looking at in here. And then, as I stated earlier, the topography of the project limits where the pool can safely be installed. So when we look at the kind of the south side of the property, which I have provided on screen, kind of a picture layout of our backyard, you'll see that on the very back on the south side of our property, there's an inclined hill that stems up into one of our butters who's located on 27th Hemlock Drive. So that incline goes up to about 9 feet at its highest point. So in order to build a pool on this side, we would have to take out a significant amount of land with a 10+ foot high retaining wall, plus all those trees, pine trees that you see in the backyard, we would have to take down and remove from that lot. So the proposed location for the ground pool, which I just stated, is going to be on the east side of the subject property, which is flat and will not require a retainer wall. In addition to the topography of the yard, the shed, as I mentioned earlier, is located on the opposite side of the property from the proposed location of the in-ground pool. And the septic systems and utility boxes, that's a non-issue because those are all located in the front yard. So basically the restrictions that I've outlined in the back is mostly pertaining to that inclined hill, which limits where we can kind of store it in the backyard. Just another shot of it, which I did want to share. This is just kind of an aerial view of what we're proposing to install the ground pool. And as you can see, it's very level. There's no need for a retainer wall to be had, and that's why we like to propose it on this side of the property line. So as part of the project, proposed project, we would supplement our existing fencing with 6-foot vinyl fencing to ensure that the pool is completely fenced in. And to restrict access, in addition to the pool, will be placed in a location that is the safest from the house, as I talked about earlier, and that will allow ample space to walk around all sides of the pool safely. Therefore, the use as developed will not adversely affect the neighborhood, and there will be no nuisance or serious hazards to vehicles or pedestrians. So what I did want to show on this picture here is, yes, there's a number of trees that we would be willing to kind of take down because the intent is to extend our existing fence that you see right here, which is about 4 feet, which is not code to have around a in-ground pool. We would extend it about 6 to 8 feet. So on this slide, you can, on this picture, you can see that our property stakes is right about here. We got it surveyed, and that's how far it goes out. So it's not, and then here's the back one back here. So there's still ample space between the sidewalk and our property line. Plus, in addition, you'll see that we have ample space between the street view. So this is just another view of, I just want to show the board as well as members that have attended this meeting, how much and how far we're willing to extend our fence, because we want to keep in mind that we do not want to obtrude or obtain any obstructions to the sidewalk. And as you'll see right here, this is the property line, and then this is sidewalk and the street, and then to the public street. So we just wanted to share that. Additionally, that was what was outlined or what was given in the package is the calculation sheet for the increase of impervious surface. So you will notice that when we do the calculation of the impervious surface that we will exceed, not well, but we exceed the maximum threshold. And part of that is due because the house was built after 1986. But additionally, if you just take the proposed project, so that's the in-ground pool as well as with the apron, it's only 943 square feet, which is less than 5% of the overall square feet of the property, which is 20,000 square feet. So I did work with Fred Litchfield. He did come on site. We walked through the site to get an understanding of what would need to be done. And we didn't get into much specifics as far as what exactly we'll need to do, but he did state that if this does get approved and if and when we do go to get a building permit, we will work together to ensure that we build and we will get the necessary recharge that is needed to ensure that we have proper coverage. So then lastly, as previously stated, the subject property is in a residential neighborhood with the use of pools and other lots throughout the neighborhood. So given the nature of this variance, and we just want to be very mindful of all of our neighbors, and we felt that the current proposed plan is the least obtrusive and provides for a safest location for all involved, in particular for one family, but also for all the abutters and for all the neighbors in the neighborhood. We had previously looked at putting the pool directly behind the yard and the fence along the property line, which is actually on this view, this last picture here. You'll see here's the back of the fence. So one of the things we did kind of consider before presented to this committee is just having the pool directly behind the house, as I said before. But we would take down these trees and then essentially we would extend this fence back another 6 to 8 feet, which as you'll see, the property line goes this, it's almost abutting the driveway actually, but there's still a little room, a few feet from it. But for our current plan, we are planning to keep the existing fence in the back as is. We're not going to move it behind the trees. We're not going to take down those trees in this backyard. We're going to keep it as is. So we thought, again, just keeping in mind of our neighbors, we just wanted to be sure that we maintain and disrupt as minimal as possible and be as less intrusive as possible. So lastly, for further due diligence that you will notice in the package, we had reached out to a number of our immediate abutters and received 7 signed letters of support, which were included in the petition. So we feel that the addition of an in-ground pool will not change the existing residential use on the subject property. And therefore, we believe the proposed use is in substantial harmony with the purposes of the Northborough zoning bylaws. With that said, I just want to thank everyone again for your time and your attention to this matter. At this point, I will open it up to hear if there's any other further questions or comments.
Okay, all right, thank you very much. All right, just give us 1 second. Okay, so members of the board, Jeff.
I just want to ask a question regarding the 2 property stakes along the sidewalk on Hemlock and then the trees. Will the new fence be right on those property stakes or right in line where the trees are? I was not clear on that. This one here.
Mm-hmm.
Will the fence be on these or at the tree line? Could the applicant speak to that, please?
Might be muted again.
There you go. Okay. So the fence will be it will be pretty close to the property stakes. We are going to give a couple feet just to give a little button room, just in case, again, just for coverage and just to not sure we're not just on top of the sidewalk as is.
Okay, so to follow up on that question, if the required setback, because this is a corner lot, so it's a 30-foot setback, how far into that 30-foot setback are you proposing your fence will be?
It will be, so we're looking for 20-foot relief for the pool. As far as the setback, I don't have the numbers offhand as far as how many feet that will be from the property line, but I can get that to you.
Mark?
I don't think they need a setback for the fence itself.
Okay.
It's just the pool is the structure.
That's what that, yeah.
Right.
That's what needs.
Right.
Is that correct, Mr. Building Inspector?
Yes, just for a point of clarification, fences that are 6 feet and less in Northborough do not have to meet a minimum yard setback. Obviously, the fences do have to be on the property and not on somebody else's property. We also advise, it's not a requirement, but it's a best practice, that if you install a fence, it is installed such that you can maintain both sides of the fence without leaving your property. That's a guideline and not a regulation. Also, in terms of fences, when you put a fence around a pool, under the building code, that pool becomes the fence becomes what's called a barrier. And there's a whole different set of requirements for the pool barrier as compared to a fence. I can get that information to the applicant so we can do a little better pre-planning. But in terms of the location of his fence where he's talking, there's real no zoning restriction on that. And I can forward him information on what would be an appropriate barrier for the pool.
Right, but I guess my question wasn't whether it was required a variance. My question was how far into the setback is the fence going to go? So if the pool is already going 20 feet in, that leaves 10 feet before you get to the property line, right? So is the fence going another 8 feet and there'll be 2 feet left of the property line? 5 inch? I mean, you're supposed to be able to maintain the fence while still standing on your property. So depending on how big your feet are, you have to have at least 12 inches, I would guess, so that you can stand up, up against the fence. So that's what I'm trying. If the pool is 20 feet and you have to have a walkway around the pool, I mean, you have to have some way of accessing the pool from all 4 sides.
And I thought they heard, excuse me 1 second. I thought they were asking for 10 to 20 feet of relief, which would make it 10 feet from the line for the pool.
20 feet of relief means they want to go 20 feet into the 30-foot setback.
Right. So that would be 10 feet from the property line. Right. I thought you were saying 20. I'm sorry.
Right. No. I mean, if I was, but I might have not said the same thing, but that's what I meant. Okay, so from the pool, you have to then put a sidewalk and then you put a fence, and that's within a 10, unless the sidewalk also is part of the pool structure. I'm just trying to get a better sense of if this, what would the, because I mean, I get that it's just the pool, but if the pool and the walkway around the pool cannot be sufficient and still get a fence within, with a foot of the property line, that's tight, that's all. And can I just ask, the fence along the backyard is going to remain a 4-foot chain link?
So around the pool, you'll see what we have right here is around the pool. That's all going to be 6 feet. We got to make sure that the pool in the infield area is at least 6 feet, just like we were saying with the barrier.
Okay.
That's going to be 6 feet.
Okay, so that'll be in addition to the chain link across the backyard.
We would remove the chain link, the existing chain link, and replace it with a 6-foot vinyl fence across all or surrounding the pool. So in the front, and the side, and as well as the back, and that's in addition to the side too. So it'll be a rectangular square fence.
Right. And you already have it across the front of the. I think I saw that. Yeah.
Yeah, but that again, that's only 4 feet, so we would have to bring it up to 6 feet to make sure it's code.
May I ask?
Sure.
Bob, a question. So I see that you're using the wall of the building as part of the barrier for the pool, but there's also a window. Does that count as an issue, Bob? Because someone could easily go out a window and get in there.
anytime you have direct access from a house to a pool area where that access is 48 inches or lower to the floor, like a door or a window or something like that, those windows need to be alarmed. That's part of the pool barrier code. So if that's a bay window and those windows from the inside of the floor are less than 4 feet off the floor, those windows need to have an alarm on them to alert anybody who opens the window and gets out and goes into the pool area unauthorized. They typically run the scope of safety for a pool for something that of a 12-year-old. You know, somebody who really should know better, you know, but is going to be a kid. So that comes under the building code. Any doors or windows leading directly to the pool area where the bottom edge is less than 48 inches from the floor requires an alarm.
Okay. Mark, did you have a question? Okay. All right. So I guess while we have this picture up, because I'm not a pool person, how big is where you have 18 by 36? Is that just the pool or is that including the sidewalk around the pool?
That is just the pool.
And is that a typical size? I mean, that's a typical size in ground pool? All right, Bob shaking his head yes.
Yeah, it
Okay.
is.
Yes.
All right. Okay. I mean, I don't know. 18 by 36. So it really would have to end up being, well, and it's the pool that has to be is in the setback, not the sidewalk around it. We're not measuring that.
Right. Primarily because he's not required to put in a hard sidewalk around the pool.
Okay.
They could use stone with flagstone, you know, foot pads or something like that. So the structure of the pool, which is the edge of the coping, is where typically we count the structure. We don't count the sidewalk or any kind of walkway around the pool.
And if this was a typical side yard, it would be less of an issue, but you wouldn't have a public way and a public sidewalk being encroached upon. Okay. Other questions? Okay. At the moment, all right. So now I have to figure out. I have to see my attendees while you're sharing your screen. Okay, there we go. Okay. So,
A question?
Yep, sure.
We were distributed a letter to my front door from the Zhangs, who are abutters. I'm not sure, this never made it in, did it, Kathy?
Yeah, we got it.
We got a letter. We got a letter as members of the board.
Okay.
Yeah, that letter came in. There was one letter that was an objection, and then there's about 7, 8 letters in support.
We've only seen the objections.
No,
Kathy?
the letters of support were part of the application.
Oh, okay, got it. Okay.
So there's
not get any letter of objections. Is that something that I should have received?
3, 4, 5, 6, 7. Yeah, there's 7 letters in favor, you know, that are supporting the applicant, and the 1 letter that's opposed. I'm sorry, who just asked?
No, that was Mr. That was the applicant. All right. So yes, we did receive 1 letter, and actually, if you give me just 1 moment, whether you should, I mean, I guess as a courtesy, yes, but no, this was a letter written to the zoning board opposing it, and it will be part of the record. And I'm going to see if the person in the audience who wrote the letter.
Yeah, he's here.
Okay, we'll speak to it, but I just want to check, make sure does town staff or board members have any additional questions at this point for the applicant? Okay, seeing shaking heads, no.
No, but Fran, I would just point out that that if you're going to read the letter of
Oh, no.
opposition, you also need to read all the letters of support.
Oh, no, I was just going to reference it.
Oh.
I wasn't going to read
Okay.
it. But I'm going to give opportunity for people in the audience, and then we can come back to the board staff if there are more questions. Okay, so this is a public hearing. So members of the audience, if you want to speak, you just need to raise your little hand and I will try to successfully call on you and then ask you to state your name and your address. So I see one hand at the moment, and that is John. And so John, I would ask that you state your full name and then tell us your concerns.
Okay. Can you hear me?
Yes.
Okay, thank you. Thank you, Madam Chair. Thank you, the board member. My name is Zhang Zhao. I'm the co-owner of the property about this one Blueberry Lane 27 Hemlock. The objection letter that you referred to was written by my wife, also distributed to some of our neighbors. So I think you have the letter. I don't have to repeat everything in the letter, but I do want to point out a couple of things for the board members. One is the amount of encroachment. I think you got that point. It's 20 out of 30 required setback. So that would basically reduce the border, the space between the property line and the swimming pool to 10 feet from the required 30 to 10, right? That's 66% reduction of setback. And I believe, I'm not an expert here, but I believe a setback is put there for a reason, right? What I can see is a reduction of this size will certainly jeopardize everything on the other side of the property line. And you saw the pictures. There's the sidewalk where children, pets, bikers, pedestrians, they walk every day. And there's something that you don't see, the underground utility line, I believe it's right there, right? And there's also the storm drain. And there's also the pine trees that's going to be taken down. And also now to say, actually, if some of your board members here, you mentioned you live in that street, the beautiful street of Hemlock neighborhood. Just imagine, if you look around the whole neighborhood, imagine there's going to be a 6 feet, 8 feet fence right next to the sidewalk, right? Just put that picture in your mind and you can actually imagine what it's going to look like. By the way, if I get a chance to show a Google map, I can show you. Right now, in that whole neighborhood, there's no front yard fence at all. Okay, so you can imagine that. And that's the first point. And also, by the way, I would ask you to consider, in the winter, when there's snow on the sidewalk, where is the snow going to go? Right? So today, the snowplow can plow the sidewalk and put the snow on the side right underneath the trees. But when those trees are gone, when there's a solid fence, where is the snow going to go? We need to consider all that. So that's the first point. The second point, I know there's a groundwater coverage shortage. The required groundwater coverage ratio is, I think it's around 3,000, and the new one will be around 5,000. Again, that is 66% over the limit. So I know there may be a plan to actually accommodate that, to remedy that, but again, this is a large number, 66%, right? So I don't know. If you don't think this will actually impact the quality of our lives, that may be fine. I can understand that. But we ought to think for our children, for our grandchildren, right? If we don't do anything, I don't think we're actually thinking or acting responsibly for our next generations. Now, the third point is the most important one. Actually, that's the most dangerous aspect of the petition. It's the front yard fencing. So the proposal actually is to put up a 6 feet or 8 feet fence along the front property line of Hemlock Drive, right? And also you heard that it's along the property line of my house, right next to my driveway. And that will certainly block the sight line and make my driveway a blind driveway. And then that creates blind spot for cars in the street, right? So it's not too hard to imagine. And because of the fence, the children or the pets on the sidewalk, they won't easily see the cars coming out of my driveway, right? Sometimes I actually back my cars out of the driveway because the driveway is not so wide. And also the children actually coming out, my children or my friends' children coming out of my driveway, they won't be able to easily see the cars in the street. And I believe this safety hazard is the reason why many towns and cities in Massachusetts actually do not allow front yard fence higher than 4 feet. I don't know if this is actually a state law. I can look into that, but I'm pretty sure a lot of towns, they don't allow that. So overall, we all live in this neighborhood, including some of you, right? We all want a safe and pretty neighborhood to live in. And to put up this kind of front yard fence will certainly destroy all that. And now to imagine something unthinkable should happen and because of the fence, right? I don't even want to go there. So in my opinion, in summary, I certainly understand, my neighbors. By the way, me and my wife, we have been living in the house for 15 years. Our two children were born in Northborough. Our older one is going to the high school in Algonquin. So I certainly understand that it's very desirable, and sometimes I can say it's admirable to actually install a swimming pool, especially in this COVID world. It's a really good thing to have. However, it is actually a far stretch to argue that denying the petition will cause a hardship. But you heard the petitioner. The main reason that they want to put it over here rather than other places because it's financially cheaper, right? Financially cheaper does not constitute the hardship. So it's far from it, actually. And on the other hand, it is actually quite clear that if allowing it actually will create a public safety hazard, as I mentioned, and also detriment to the neighborhood, the beauty and all that, the harmony in the neighborhood. So me and my wife, my family, and also actually a couple of neighbors who signed a letter with us to support our view, we actually strongly oppose the petition, and we actually respectfully ask the board to actually deny the petition. So that's all I wanted to say. Thank you.
Thank you, Mr. Zhang. If I can just ask you, do you know how far from the corner of the property line where the fence would go is from your driveway? Like,
you saw the yardstick. It's about 2 feet, maybe slightly less.
Can I add to that?
One moment, please. Okay, all right. Mr. Elia, do you have that information?
Yeah. So if you don't mind, I'm just going to share my screen again because I will pull it up because that's what I wanted to stress when I talked about this was the picture here.
Okay.
So this is the property stake, which he is correct. We were only talking about a couple feet from his driveway, but that's why I stated that we're not moving our fence back to that property line. If we were moving that fence back to that property line, I would fully understand where he was coming from, but we're not. We're not moving it at all. We're keeping it to where it's existing right now. All we're doing is extending this corner.
Okay. Out that way.
Yeah,
okay.
Up this way.
Okay. Well, I mean, I'm not going to, yeah, because there's another setback in the back there as well. So yes, you could not build your fence back to 2 feet off of his property line without another variance for that backyard setback. So well, I'm sorry, because there is no fence setback. So it's where that black fence is moved out toward the sidewalk.
Yeah.
Right. But so that's, all right. So Bob, just because you can look at that picture and tell me from the Zhang's driveway to that fence, how far is that about?
Hang on.
I'm just trying to look at the line of sight and the concerns that the abutter just mentioned, pulling out of his driveway and being able to see the sidewalk.
I'm going to guess 10 or 12 feet.
Okay, so the stake is the corner of the property line, right?
Yep.
And the Zhang's driveway is to the left,
Mm-hmm.
which appears to be somewhere, I'm going to guess, between maybe 4 and 6 feet.
Right, but from where the black fence is, then that's if that's another 10 feet. I'm just trying to see if you back out of that driveway, how far you have to go across the sidewalk before you'll be able to see past the 6-foot wide fence to see if there's anybody on the sidewalk or in the street, without having to go out there myself. I mean, you know,
that's a very debatable point.
Okay.
One of the regulations regarding fences is it cannot create a blind spot. In the fence, the minimum fence requirement for around a pool is 48 inches.
But a blind spot for a private way or for a public way?
Anybody.
Oh, okay.
It doesn't.
Okay.
Blind spots don't discriminate.
Okay.
Now, if it's a chain link fence like that, is that considered a visual disturbance?
No, chain link fence is better in terms of visibility. And, you know, depending upon how the chain link fence is installed, that does also qualify as a pool barrier. So you know, if the applicant were to change the fence design slightly, he could get himself a little relief and have be able to install his fence where he would like and not create a visibility issue.
Okay, thank you. All right, I just messed with my view, so I'm a little lost here.
Can I ask a question?
Absolutely.
Can Fred speak to the snow removal issue?
Oh, actually, no, I was going to actually ask the applicant that because it's the
okay,
homeowners, the homeowner who has the responsibility to shovel their sidewalks. So the applicant would have to explain where is he going to move the snow off of the sidewalk that he's legally responsible for clearing.
Yeah, no, not a problem at all. As I normally do during the winters, I always, I have the snow blower that I will clear the sidewalk in, but you can see there's space on this side of it that I will be able to, whether it's snow blow or shovel, just to remove it so it's not clogging the sidewalk. And there's also space, I believe you can see it on this side. So this is all going to open up. So there's going to be a stretch where, yes, it will be tight, but that's not to say I can't remove snow just like we all do, whether it's at the end of your driveway, just to move it around the corner or move it into the front. So
you could blow it over the fence.
Exactly.
Blow it. Yeah. Okay.
Right.
All right. Okay. All right. Thank you. All right, I'm sorry, Leslie. Did you have another question?
No, that was it. Thank you.
Okay. All right. Okay, so I'm going to move back to the audience, and I believe this Mr. John's wife, maybe. I'm not going to even, Mrs. Zhang. Did you want to speak?
Yes, madam.
Thank you.
My name is Xiao Zhang. My husband just talked, and we sent you the letter because originally I thought I couldn't attend since I was given the opportunity to talk. I was able to try to make it tonight, and I really appreciate it. And first of all, I don't know how to share my screen, but Mr. Elias, the petitioner, had just showed the board members a picture about the fence.
Mm-hmm.
On the picture, it said the fence all the way up to my driveway. If I could, please ask the petitioner show that picture of the pool again, or
the part of the fence that is along your driveway.
Yeah, showing
Okay.
the picture of the pool size.
Okay.
Thank you, Mr. Elias. No, the pool drawing, the one from the survey.
Oh,
With
the pool
size.
drawing.
Yeah, please.
Okay.
You can see this. This is the fence. Right now, the fence is right here. The fence. This is the property line. Unless I misunderstood, Mr. Elias said a different thing. This is the fence. This is the property. Less than. You can see from the picture. That's their drawing. That's the plan.
If I may, I think my wife is trying to say, according to this picture, this is inconsistent with what Elias just said. The fence actually got moved out all the way to the border.
Unless that is just a border to depict the property line.
Correct.
That is the property.
This does not consist of our existing fence structure.
Okay.
It only consists of the proposed 6-foot fence that will be surrounding the pool area.
Right. I think that's what we're saying. The solid line with the cross on it. So that is actually almost connect with the border already. It's not what was said in the meeting.
All right. I understand what you're saying. So the pool fencing with the X's without having measurements on this screen appears to be much closer to the property line than when you look at the perpendicular view from the street.
You got it.
Okay, I got it. Okay. All right. Okay, so I want to that was the only two people in the audience. Okay, so, all right.
Madam, if I would please, sorry to interrupt you.
No,
go ahead. Thank you. And also, I got signed letters from the neighborhood, immediate neighborhood, and joined me for objections.
Okay.
And normally, if for face-to-face meeting, I was told people just bring the petition letters and present to the board.
Okay.
How am I going to present those signed letters, signed petitions that show their objections?
Okay, I'm going to ask Kathy, given the fact that we're virtual, is that something that you can take even if the hearing is closed tonight? You can
No.
reference them. You can tell us then you
The
can.
names and address?
I would hope that that would be enough, but I'm going to just wait and see if the town planner knows how to address that, given we're not in person.
Thank you.
What, I mean, if you close the hearing tonight, you know, you can't take in any additional information.
Okay, but if she reads the letters to us and then subsequently mails them to you, so you have the hard copies for the record, is that fine?
Yeah, it can be read into the record, yes.
Okay, all right, so they can be read into the record if you would like to do that.
Thank you. And one more question. Please forgive me about my ignorance. For the petitioners' supporters, I know maybe this is not a public record. Can I know, are they immediate neighbors or they are, you know, far from the location?
Okay, so it is public record and it was submitted by the applicant in hard copy with his application process. It is also going to be part of the record. What I would say is, if you want to, you would have to read yours into the record because you're not physically here. And after you do that, I'm happy to just add and read into the record the letters that we received. I mean, at least I'm sorry, Kathy, should I just do names and address, or should I mean, how should we do that for equity purposes?
Yeah, sure. I mean, we can, I mean, the letters are already part of the record.
Okay.
So if you just wanted to, you know, say their names and their addresses.
Okay. All right. So Ms. Zhao, I will tell you that for the record, in favor of this application, there are the McGinnises at 34 Hemlock. I apologize, I don't know the last name, at 32 Hemlock.
Yeah.
The Wisers at 32A Hemlock.
Mm-hmm.
The Johnsons at 30 Hemlock. Michelle, I apologize, last name, at 4 Blueberry Lane. H something at 3 Blueberry Lane, and J Hannah at 2 Blueberry Lane.
Thank you.
So now if you would read your letter, because we don't have the actual letter, I would need you to actually read
name and address.
Well, and read the letter, actually the substance of the letter.
Okay.
Because we don't have copies of it.
Oh.
Please allow me to do it. I have the letter in front.
Okay, that's fine. And this is Mr. Zhang speaking.
That's right. That's me. Just for the record, the content of the letter is exactly the same as the letter I sent to you already. It's just the address, the person who wrote the letter is different. So maybe for the sake of saving time, I could just read you the name.
Okay, so they would not have written a letter that says, I am the property owner at 27 Hemlock. So what is the introductory paragraph?
We live in the neighborhood of 1 Blueberry Lane.
Okay, thank you.
So, yeah.
And they're expressing objection or support?
Objection.
Okay, and their names and addresses are?
The first one is Yan Chuan Li. I'll spell it for you. First name, YANCHUAN. Last name, Li, LI. The address is 6 Blueberry Lane.
Okay.
And the second one is Wan Yik Li. I'll spell it for you. WAN space YIK space LEE. The address is 25 Hemlock Drive.
Okay, thank you.
There's a third one actually.
Oh, sorry.
Yeah. The last name is UYU. First name is YU. Last name is Liu, LIU. The address is 6 Laurel Avenue.
Okay, thank you.
And I'm sorry, there's actually another one. The first one just came in. First name, Hongmei, Hongmei. Last name is Cai, Cai.
Address?
The address is 3, right? 3 Blueberry Lane.
Okay, thank you.
That's all. Thank you very much.
All right, thank you. I also see there is a person whose last name is Ria, I believe, in the audience with their hand raised. I'd like to be able to call you, allow you to speak. I need you to state your entire name and address, please.
Madam, sorry to interrupting. I just had one sentence to add.
Okay, I'm sorry. I just want to, I did ask somebody else if they wanted to speak. So I'm going to, I'm going to ask you to hold off on your point.
Sure,
and see if Ms. Rhea or Mr. Rhea wants to speak. Oh,
hi, it's John. Can you hear me okay?
Yes, we can. Thank you.
Hi,
Sorry,
this is Jonathan Ray. I'm a resident of 3 Laurel Avenue.
Okay.
I don't have a letter, so I'm not part of any public record or any of the conversation.
You are now.
Well, thank you. Yeah, I just want to, I'd just like to say that I am a frequent walker in the neighborhood in Laurel, Hemlock, and Blueberry, and I have no objection at all for this project to happen. I don't see any sort of nuisance at all, and I have young kids. I don't have any fear of safety or anything with that, and I find that the neighbors here are great at keeping up with their sidewalks and their yards, so I don't have any real reason to think that this would be a bad thing to prevent someone to do, and would not take away from my quiet enjoyment of where I live.
Okay, thank you very much. Okay,
Madam
Miss. Oh, okay. Yes, Mark.
If I may interject, I believe one of the listed opposition letters was at 3 Blueberry Lane.
Yes.
Yes.
And that was also one of the support letters. Was
Yes.
3 Blueberry Lane.
Yes.
Interesting.
I was pointing that out. It's
So
interesting.
can you tell which one was signed later?
Yeah, say which came first.
Okay, well, why don't we just have them be net neutral at this point? Okay, Ms. Song, you had another point you wanted to make?
Yes, and the address for the Laurie Avenue, my husband didn't see clearly from the signing, and I need to also confirm, but the name is correct. The name just Mr. Rare, it's not from him. I'm sorry, must be number is kind of confusing. I will confirm, but the name is right. Last name is Liu, first name Yu.
Okay, and what is their address?
It says 6 Laurel Avenue. I'm not sure it's 5 and 6, and I would confirm on that.
Okay, all right, that's fine.
And also for 3 Blueberry Lane and Hong Mei Cai. She's on the meeting right now.
Okay.
And I think she wants to talk.
Okay, thank you very much. Okay. I do see one more hand up in the audience, and so I'm going to ask that person to state your name and your address, please.
Hi, this is Hongmei Kai. Can you hear me?
Yep, and what is your address, please?
3 Blueberry Lane.
Okay.
So
Mystery solved.
So when my neighbor first told me about they were going to build a swimming pool, I did not think that much. I thought, okay, it's fine, no problem. So I signed it, but I did not know all the details about the fence and everything, how close the fence would be, to the sidewalk, everything. And so now I know the details. I do have some concerns about the safety. I walk in the neighborhood a lot. I jog. I really think it could be dangerous if I don't see the cars backing out from John's house.
Okay, all right, thank you. Okay, so board members and or staff, do you have any additional questions or concerns for the applicant? Oh, Jeff.
I did have one, and that was just in regard to that, the survey plan or the plot plan that shows that fence. Would the applicant, if this were approved, but with a condition that the fence was to remain no closer to the Zhang's property than it is right now, would that be a condition that would be an issue?
That would, so this is Jonathan Alia, that the applicant, that would not be an issue. I mean, the fence is really to stay compliant with the pool code. So we are flexible in moving it as needed as such in order to comply as such if there's any other conditions from the neighbors concerned.
Okay. All right. Thank you. Okay. I am now being mindful of the fact that we're coming to the end of our support staff here. So I do want to ask who, oh, Mark, yes.
I guess building on Jeff's question, would the applicant have a problem if the 15 feet of roadway abutting fence closest to the south side there also be chain link instead of a continuous vinyl or whatever is the proposal? In other words, it would limit your privacy, but that's not really next to the pool. It would instead would be, it would just give a little more visibility into the driveway. How do you feel about that, Jonathan?
So just to be clear, we're talking about the fence pretty much all on Hemlock Drive, correct?
Yeah, in other words, not that the fence on Hemlock Drive would all be chain link, but if the 15 feet on the south side on Hemlock, so it would be two different fences, both at 6 foot level.
Okay, no, thank you for clarifying. That makes sense. I don't believe that would be an issue.
Okay.
Okay. All right. Thank you, Mark, for that.
Just curious why, since code is a 4 foot fence, why are you going with a 6 foot fence?
So it was always my understanding that we needed 6 foot fence for a code, but if it isn't, I mean, again, it's more for safety reasons too. We would feel more safer with having it 6 feet versus 4 feet. Just again, we have young children, and being that will be a button on the sidewalk. The last thing we want is people trying to jump over the fence. So the higher the better. Except not 8 feet.
Mm-hmm. No. Yeah. Thank you. Okay.
Dear board members, can I have one last question?
One last question.
I just want to confirm one thing. For the objection letters, this petitioner's property has only 2 direct abutters. Us, 27 Hemlock Drive and number 3 Blueberry Lane. And we are the only 2 immediate neighbors. We both against strong objection.
Okay, thank you. Okay, we do have another hearing, so what is the pleasure of the voting members tonight?
I'd move to close the hearing.
All right, that's Jeff.
Second it.
Thank you, Dick. Okay, that's a motion and a second. Roll call, all those in favor, Jeff?
Aye.
Dick?
Aye.
Leslie?
Aye.
Mark?
Aye.
And Fran, aye. Okay, thank you very much. Okay, it is, okay, we're gonna have to move along here. We're on to, oh, there we go. All right, the last one of the night is to consider the petition of Christine Anderson for a variance special permit with site plan approval, special permit groundwater protection overlay district to construct a single car attached garage at 10 Prospect Street, map 55, parcel 94, located in the residential G zoning district and groundwater protection overlay district number 2. And I am going to see, is the Christine in the audience? This must be Christine Anderson. I just unmuted you. And Ms. Anderson, do you have anyone else with you this evening who wishes to speak?
Yes, I have my carpenter, Jim Dagno.
Okay, and I see a Jim, so I'm letting in a Jim. If it's a different Jim, please be honest. And who else? I'm sorry.
That's it, just Jim.
Okay, fabulous. Okay. All right, so if you could tell us what it is that you're seeking a variance from this board, for what purpose?
I want to build a single car attached garage to my house. I'm on a corner lot, which has two 30-foot setbacks. And where the current driveway is where the proposed garage would be. The variance on the front corner, the measurements on the front corner is 18 feet. It goes out to 18 feet. So out of the 30, so I need the like 12 feet variance. It's really for the front corner, not the back. The lot is a funny shape, as you can see on the map.
Mm-hmm. Okay.
So that's basically it.
Okay.
It would be in the footprint of the current driveway.
All right. And just for the minutes, I am bringing back Brad and Paul as active voting members of the board for this hearing. Okay. So.
I'm here.
Thank you. Okay. Questions for the applicant?
So, yeah. So, Madam Chair.
Yes.
You said 18 feet and you're asking for 12 feet. Does that mean you're asking for 6 feet of leeway, or are you asking for 12 feet of leeway? So how far are you going to be from the property line?
My understanding is that it's 18 feet from the property line.
Okay,
So you're already there. So, okay. And then
that's 12 feet of relief.
12 feet of relief. Thank you,
Okay.
Madam Chair.
Okay.
That was the word I was looking for.
Okay.
So 12 feet of relief. Okay.
12 feet. Yeah. Yeah. It's just a little part of the corner. And a triangular shaped garage doesn't work well with a car.
Mm-hmm. Okay. Is there any issue on the side, on the back setback, or you're?
No.
Okay.
No. Not at all.
Other
No,
questions?
just they located the house on the front forward corner, so.
I know it's late, but we still have to make sure we get it right.
Mm-hmm.
Is it one car or two car garage?
One car.
Okay.
Plus a lawnmower.
Okay.
Madam Chair, can we confirm what is the increase in impervious surface?
I don't know what you're talking about.
That would be the width times the length, right?
Yeah, but you're building it over a current driveway, correct?
Yes.
So,
I don't know.
Hi, it's Jim Dagnall here. I'm not sure if I'm coming in.
Yes,
Yeah,
you
you
are.
Yep.
Okay. Yeah, it's currently over the paved driveway that's there now. All right, so no disturbance to the impervious area.
so there's no increase?
Nope.
And it's going to be attached to the house. Are you going to have access to the house from the garage?
Yes.
Yes, from the garage as well as from the driveway
Okay. Well, that's good.
and from the backyard too.
Okay. All right. So you're shortening your driveway by placing it actually at the end of your driveway.
Yes.
Or basically, I'm just putting a covering for the car when it goes in the driveway. I'm just putting a covering over the car.
So if people, aren't familiar with Prospect, Prospect is almost a loop road.
Yes.
So this applicant lives on the corner lot, but both roads are Prospect. So she's on Prospect and Prospect.
Yes, yeah, it goes around the corner, and on the opposite corner, it actually turns into another street. It's Mulberry Lane, but it stays Prospect around the corner. And the corner is literally a right angle, so.
Yeah, and it's off of Pleasant Street.
Mhm.
Yeah.
Mhm. Okay. All right, well, we won't belabor the point. Does anybody have any questions or concerns for the applicant?
And it is, I don't know if it makes a difference to the board, but it is a carport, not a full garage.
It is a garage.
Oh, it is a garage.
Oh, I'm sorry. I thought it was a carport.
No.
Okay, I'm sorry.
So, yeah, that's what I thought too.
No, it's a garage.
I have
Small.
one question.
Oh, yeah.
What's the distance from the back property line to the new garage? How close is it?
37 feet
Okay.
at the shortest point.
And so is this just a one-story, like you were saying, just a one-car garage, lawnmower, storage? There's nothing above, maybe a loft for more storage, but there's any rooms or anything like that? Okay.
Nope.
Are you going to remove the shed in your yard?
That shed has been gone for 8 years.
Okay, that would be a yes. Okay. Okay. All right. Anything else, anyone? Any staff? Okay. All right. What do I
Madam Chair,
hear?
the last thing, like, do any
Sure.
letters of objection or support from
Kathy?
the neighbors? I mean,
No, we didn't receive any letters either way.
Okay.
And I just want to point out again on the one of the maps that was attached, it shows right in the immediate neighborhood, because I'm just thinking this was similar to Rustic Drive. But there are several houses that have garages and a couple that don't in the area, in the immediate area. So it doesn't appear that this would be out of place at all.
Okay. All right. Well, thank you, Kathy. All right. This is a public hearing. So if there's anyone in the audience that wishes to speak regarding this application, I would ask that you raise your hand and you will be recognized. Okay. Seeing none, do I hear a motion from the board?
I move that we close the hearing.
Thank you, Mark.
Second.
Thank you, Dick. Okay, I hear a motion and a second. Roll call for all. Mark?
Aye.
Dick? Paul?
Aye.
Brad? You're muted.
aye.
Thank you. And Fran, aye. Thank you very much, Ms. Anderson. Okay, so Kathy, what do you want? What do you want us to do about our time?
You're muted, Kathy.
That's what most people want me to be, is muted. I was going to.
Not true.
I was going to say is just to be mindful of the time. I mean,
Okay.
it's 9:35.
Okay.
You know, I mean, I realize you have 3 decisions.
Okay.
I jinxed the meeting from the very beginning by telling Becca, oh no, these ZBA meetings.
Okay. All right. Well, let's just roll through. Let's just go from last to first and stick with the 10 Prospect Street, because I think that is the simplest of things that are before us. Mark, I always rely on you to make sure we word it in a way that we're not undoing what the intention is when we're talking about setbacks, but I'm happy to hear from anyone that may or may not have any concerns about it.
I have no concerns. This is not cutting off visibility. It's providing a nice place. They're parking cars there already. It's not increasing the impervious cover. Yeah, this seems very, very reasonable.
Okay, thank you.
I think we should give them 14 feet just in case.
Okay. All right. Does anyone have any concerns or objections to Mark's recommendation? All right. Does somebody want to put it in the form of a motion?
I move that we grant a variance to 10 Prospect Street to allow an incursion into the 30-foot setback on, would this also be a front of the property?
Yes.
Yes. A 14-foot incursion into the 30-foot setback to allow the construction of a garage on the south side of the property.
Oh, I think she, okay. And so they were going 18 feet into the setback, leaving only 12. So we should
No,
actually,
I got the impression they were going 12 feet into the setback, leaving 18.
oh, I
That's
had,
what I was confused about.
Yes, I
No.
I agree with Mark.
oh, okay.
I'll second that.
Okay, so we have a 14-foot, what'd you say, incursion?
I have nothing
that the word?
against giving them an 18-foot incursion in case I'm wrong.
All right. No, I just was going with the word. I mean, I'm fine if three.
Encroachment.
We don't have to
Encroachment.
hear this again if we said they can get an 18-foot encroachment.
Okay, I would be more comfortable with that because that's what I thought I heard, and I would hate to
Okay.
bring them back. So, okay, so there's a motion made by Mark, seconded by Dick, to give them 18-foot relief from the 30-foot setback. Yes.
Second.
Okay. All right, we already got the second, but thank
Yep.
you for the third. Okay, so roll call. Mark,
Aye.
Dick,
Aye.
Brad,
Aye.
Paul,
Aye.
and Fran, aye. And sorry, I get worse as the night goes on. Okay, so moving back. All right, so moving back up to 1 Blueberry Lane. Paul and Brad, you're welcome to stick around. You don't have to go silent again or blind again, but you would not be part of the decision discussion because it is the other 5 members. So Leslie, Jeff, Dick, and Mark.
If I may, Madam Chair.
Yes.
I guess my feelings on this is that, yes, there is a fence, and yes, it may provide a blind spot for that driveway. I think that the proponent was amenable to take that out with a transparent fence near the driveway. I also would note that I don't believe there's anything that prevents him from constructing the fence other than the blind spot. In other words, he could put up the fence. Now, there'd be no reason if he doesn't have a pool behind it, but if he wanted privacy there. I also know from having lived in the neighborhood that those trees that he's considering removing along Hemlock Drive used to be full fir trees all the way to the ground and in fact encroached on the sidewalk quite a bit. And it's only with age that they've been matured and he's cut them off to provide passage along Hemlock.
Okay. All right. Thank you.
Over time.
Okay. All right. We're waiting for Jeff to come back because his computer crashed, but we'll keep talking and catch him up to speed when he comes back. Or should we skip over Kathy and move on to the other one while Jeff is having computer trouble?
Yeah, he's a voting member on
Mm-hmm.
Blueberry Lane. Yeah, so you should probably pause
Okay.
this and.
All right, we're going to pause this one and go to the 329.
Everybody, I'm gonna go
Bye-bye.
silent and dark. See you later.
Bye-bye. All right. Okay, so for 329, what's before us is whether or not we agree with the determination of the zoning enforcement officer and the town council that the contractor's yard as a use on 329 has been continued without a period of more than 2 years of non-use. And separate from that, is the use meet the definition of a contractor's yard? And the fact that they're parking on 333 is not relevant to that discussion. Jump in, anyone. Dick.
I just want to say, I don't see that there's been a cessation of the use since 1987. So I don't think there's been much of a change. It's been less exhaustively used recently than it was in the past when Zeco was there, but it's always been used consistently for this type of work and this type of business. So
Okay.
I don't see that interruption.
Okay, all right. So keeping the 2 points separate, Brad, Paul, and Mark, what are your thoughts on whether or not the non-use was properly verified by both town council, the staff, the letter that we received, as well as the zoning enforcement officer's interpretation?
So I think generally speaking, right, ZECO was using this. They got the 87 approval, to bring some chemicals on board. At some point that got, limited down through attrition where, the use of chemicals was either, nothing or no longer continued, right? And for backup, it's the Lamborghini case, right? Part of the Lamborghini case that we heard was he wanted to bring his trucks on and he wanted to bring chemicals back onto the property. The Lamborghini case came in front of us, presented, right, and continued that use. I think that the neighbors did show that there was, I think the one thing that was shown on the current owner, right, was the letter, right, from ACV. And if you look at that letter, all ACV says, right, is that they operated an office building at 329, right? And never really expanded upon the fact that whether or not they had trucks there or didn't. Now, having trucks on the property, whether it's 333, doesn't necessarily constitute a continuation of use, right? Because that's not what we're looking at. So I think that the case was made that there was a slimming down of the use, right? And based on the photos recently, whether it's, and that's allowed or not, that use has expanded, right? There are now more trucks there, okay? The trucks that are there is some kind of a chemical reduction thing, okay? There's a tree service there that was started in 2013, I believe, which was after the 2009 bylaw adjustments. And so I don't think that you can, and this is my opinion, that you can wrap 87 and the special permit and what ZECO was using it for, right, which was removal of chemicals, into the whole entire contractor yard use. That's in my estimation, because then that allows you to sort of just wheel out into all different things, when the idea of changing bylaws, slimming down, grandfathering, right, means that you go from whatever the use was, and you, if anything, you're getting smaller, not bigger. And I think based on what currently exists there, it's getting bigger. It's expanding. They're looking to now pave the lot, right? They're now looking to expand their use. And so I think that goes against sort of the integrity of what our bylaws are trying to do. So
true, but do you think that there's a do you think there was a stop of use for the contractor's yard for more than a 2-year period? Because that's what they're appealing. They're saying that the contractor's yard as a total use, regardless of who was using it, as a total use, was that stopped for 2 years or more?
Right, so we have two different opinions here. We have someone that says it wasn't stopped. We have someone that says it was.
Yeah. Well, that's true. That's true.
I mean, I guess we never really asked for more information as far as, hey, can you prove that you've now continued to use for the last 20 years? And then we've also didn't get the other side of it to say, hey, prove that, they didn't stop using it. The information that we were shown was, hey, there's trucks here.
Right. But but again, Paul, we did get the building inspector made the decision or the determination that there was a continued use, right? Sure. So we're not the ones questioning that decision. There's two appellants that are questioning that decision. We're trying to determine whether his decision has merit, and that merit would be based on his experience and his inspection, town council, and the
Right.
supportive documentation from a
From the applicant.
user of the contractor's yard. We didn't hear from the welder or from the other people. We heard from one. So again, it's just, is there still continued use of a contractor's yard?
That's the question, right?
Yes, it's still the question.
And so, Madam Chair,
Yes.
so I can piggyback on that. Based on this property, which is very controversial. Actually, do I have my mic in? Everyone hear me okay?
Yeah.
Yeah, you
Okay.
can hear it fine.
Sorry, I had my mic up, which is very controversial. I decided to keep a lot of documentation from previous hearings. And one of the reasons why the Labadini case came in front of us is because of the lack of use for 2 years. And we've seen documentation, we've seen timelines that for 2 years, it hasn't been used as a contractor's yard. And at a minimum, if you're looking at 7-08-020, it says that may grant a special permit to change a non-conforming use in accordance with this section only if it determines that such a change or extension is a similar or less detrimental use. So at a minimum, they should have come in front of the zoning board with changing hands at a minimum. All right. And so in what's going on with the trucks, 333, whatever that may be, I think at a minimum, they should have come in front of us to decide whether it's the contractor's yard or not. Because in 2009, we rezoned that area, and that is no longer zoned as a contractor's yard.
Right.
So for that reason and that reason alone, then I have to I have to go in favor of the appeal.
All right. So what you're saying is it didn't come before us because the zoning enforcement officer did not agree with that. And his decision was that it did meet the same criteria, and therefore they didn't have to ask for a variance from us because he didn't deny them.
Well, it's not it's a special permit. I know it's getting late. Don't worry.
I'm sorry, special permit. Right. So he didn't
but it
deny it. So that's
changed.
why it didn't have to come before us because he didn't deny it. And that's why they're appealing it.
Such change or extension. So an extension. So even if it still was as an extension, I feel as though based on our bylaws that at a minimum, they should have come in front of us. They shouldn't just park their trucks there and set up shop.
Okay. So again, so that is what you're saying is you disagree with Bob's decision.
I do. And
Okay.
that pains me to say, because I respect Bob's interpretations but at this, I know this, and this is a tough property. It's always going to be a tough property.
That's, I guess it's not, that's fine. Okay.
But
Mark.
I leave my emotions out of it.
Okay. I guess I take the opposite tack in that the applicant did go to Bob, which is who he's supposed to go to. Bob said, you don't have to go in front of the board. You're fine because you're grandfathered in by the 87 decision. So yeah, what we are hearing is not whether the applicant did anything wrong. What we're hearing is, do we disagree with Bob's decision that there was either a change of use that should have been heard by us, or do we disagree with his decision that there was a discontinuance of 2 years of the current use that invalidated the special permit? Bob decided that there was not 2 years. All the petitioner has demonstrated is that they called up someone at the company who answered the phone who said they had left, but the legal representation, or I think the officials of the company had a different view that they had continued use of the property. And and in fact tried to demonstrate that they have continued use. So that to me answers the continued use of there was not sufficient the applicant in looking for the override of Bob's decision has to kind of prove that there was abandonment of the property or a disuse, and I don't think they demonstrated it here. That may be the case. As I say, it could be the applicant is lying through, the owners are lying through their teeth, but again, to me, that wasn't demonstrated. They were asked, hey, are you officially asked, and their lawyer said, yes, we have been using it, and here are photos to prove that somebody's been on it. I also kind of buy Bob's contention that the whole idea of a contractor's yard is a very general term, and as long as you're not increasing the detriment or the danger, as Labadini wanted to do by bringing chemicals onto the property, that they are not they are not stepping over. Yeah, they are doing something different. Yeah, they are upping or raising or lowering the amount of activity, but that's kind of consistent with how a business runs. You sometimes have sales that are large. They have had violations as far as the storage of the tree debris on the lot that should be cleaned up. They've been parking trucks in the wrong places. Those are both violations, but they are not discontinuation of the business. And I think Bob was correct in saying both the business had continued without an interruption of 2 years, and that it was still a contractor's yard.
With at least one of the tenants still there continuously, which is the welder.
Right.
Using one of the bays, yeah.
And also the demonstration that there have been trucks parked there, sometimes fewer, sometimes more.
True enough, yep. But again, I just to make sure that, so abandonment is not at question, it's the not use.
Yeah.
And he said not all necessarily. To keep the protection of the 2 years, you can't totally go no use, but as long as there are some uses, and obviously there have been some use, if not the same use.
Right.
I mean, that's what we were told in previous applications. I mean, there at least was an office there.
Mm-hmm.
I don't think they were using it as a storage for trucks, based on, what I've seen driving through there, and based on, what we've heard in the past. But the ACV, I think, ACV at least did have some presence there, where there's just a little office.
So they do need to, clean their act up. That's for sure, right? And the SNS has now inherited a mess that they're going to have to fix. But is it a fix that had a use that continued without a 2-year gap? And then second to that, is it all encompassed in a contractor's yard? And everything else is not, again, it's a messy piece of property, but that's on the owner, not on that's unfortunately, that's for Bob and the Board of Health and everybody else in the town that has the authority to clean it up. But we can't say no because they're not doing it well. But they also shouldn't they can't get, anyway, so. Dick I think just Dick, do you have any comments or concerns, thoughts?
I don't think they demonstrated that it was, they abandoned the property or they stopped the use of the contractor's yard for any period of time. There were no specific dates of time that they could, articulate about that this place was closed. I mean, it's been in use since 1987 in some form or another that reflects being a contractor's yard. So.
Yeah, it's just, it's the enforcement, but that's not, I mean, that's the problem, the lack of ability to enforce the rules, but that doesn't mean that we get, you know, I mean, I don't see an issue with Bob's decision, interpretation, or determination of the zoning bylaws. I do think it's a lousy piece of property, the way it's been maintained, and the new owner is going to have to get it straightened out along with his tenants. But I don't think that's grounds to override the decision of our zoning enforcement officer. I mean,
Leslie or Jeff, any opinion?
please. Jeff.
See if
Or
you
Leslie. There you go. We can hear you. Oh,
Sorry about the technical difficulties. I said it earlier, and I think it's there. The use has continued. I think there are definitely enforcement issues that have to be worked on to protect the neighbors. And really, I follow what Mark said, and I'm pretty much in total agreement with what he articulated.
thank you. Leslie?
Yeah, pretty much the same.
Okay. Oh, for a second there were two. I saw Jeff twice.
Oh my God, two Jeffs. Oh no.
Okay. All right. So unless anyone has any other points to make, we should move this along and see whether where it lands.
How do you want to make this proposal?
All right. So you would
Positive that we
the motion, I mean, the motion should be made to, you can either motion to uphold the decision of the zoning enforcement officer, or you can make a motion to grant the appeal to the appellant, I guess. I mean, we usually go on the positive and then so Kathy, is there a more legal way of saying it? Or?
No, I mean, I think you're right, Fran. In past decisions, you usually go with the in favor, and then you take your vote. But I mean, you could technically also vote to deny the appeal.
Oh, there you go. That's another option. Okay.
Where I'm going, I mean, at what point, where's the threshold? In other words, do they need 4 votes to
yes
uphold the override of the zoning officer, or does he need 4 votes to sustain the zoning officer's decision?
Yeah.
So right. I mean, it's sort of the same thing.
No, it's not. No, it's not.
I mean,
because if you vote to grant the appeal, that's different than uphold the zoning enforcement officer.
Oh, absolutely. Absolutely. Oh, okay. So maybe I just misinterpreted Mark. I was saying either, it needs well, not needs, but I mean, you would either be,
a supermajority has to be in
right.
agreement.
So you would either be agreeing with the appeal and granting the appeal, or you would be upholding the building inspector's interpretation.
Okay. To be transparent,
I mentioned that.
Consult the board. Obviously, I would like to propose that we uphold the appeal, and then I'll vote against it. And I think I'll be joined by enough of the board to certainly not get the supermajority that they need. But, I want to do this right and fair.
Well,
I think that's it has to be done.
Right.
Madam Chair,
Yes.
if we take a vote tonight,
Mhm.
do we have to have do we have time to then work on how we're going to actually phrase whatever the decision is after the vote is taken? Or do we need to or can we delay the vote, which I think we can, to the next meeting? Even though we've closed the hearing, we can't take any more information, but I do believe we can delay the vote until next meeting, figure out how we're going to proceed with whatever it is the vote's going to be, and then come back next meeting.
If you thought that the time between now and November 24th would change the minds of any of the 5 of us, or you would give thought to it, sure. If not, it doesn't matter. I mean, you make a motion to grant the appeal,
Yeah.
Okay.
right?
I mean,
Right?
yeah, I guess I don't think that my mind is necessarily going to change.
And there are no conditions that need to be developed or anything, right? It's just a
No.
yay or nay.
Yeah. Yep.
So-
Mhm.
Yeah,
So-
no conditions. It's just, yeah, basically.
Right. Yeah. I mean,
what,
motion to grant the appeal,
or
right?
Enforcement officer.
Vote it and we're done.
But see, I said that still doesn't make sense to me. I'm going to go back to, all right, so we'll do a straw poll, right? If you, to grant the appeal, 2 people are going to say yes, 3 people are going to say no.
Well, how do you know that?
Or if it's 4 people, I mean, we
Yeah.
don't. That's what we're trying to say. It's the opposite. It sounds the opposite to me. So, but
As long as you understand what you're voting on it, right? I mean, it's
Okay.
4, it's going to require 4 either way, as long as you, or 1.
right, yeah, I think that's true. Okay, so go
4, I
ahead,
mean-
Mark. Well, let's give it a shot.
I guess before I make my motion, I'll just say that I think my own feeling is to override the decision of the zoning officer takes a supermajority, 4 of us to say, no, Bob, consider it the other way. So I guess I see that rather than saying, oh, let's vote to I don't think it needs 4 of us to say, let's sustain the zoning officer's decision. Otherwise, it's like, 2 people object and therefore the zoning officer is wrong. That just doesn't make any sense to me. So I'm going to phrase it as, I move that we sustain the appeal and override the zoning officer on this case.
What?
Second.
Okay, so Mark has made a motion to, you said sustain the,
Carry the appeal and override the zoning officer.
okay, so Mark has made a motion to grant the appeal of the decision of the
Right,
zoning
okay.
enforcement officer, and Dick has seconded it. Okay,
You just repeat that.
okay,
Your motion is to grant the
My
appeal.
motion is to grant the appeal and override and direct the zoning officer to change or override the zoning officer's determination.
and Dick seconded it. Okay, and now on a roll call, Mark,
Nay.
Dick,
Nay.
Brad,
Aye.
Paul,
Aye.
and Fran, nay. So by a 3-2 vote, the zoning board of appeals does not,
Well, the application
well,
to override.
right, yeah, was denied, I guess. And if that's not enough, I mean, town council, let us know. I don't know.
Yeah,
I don't know.
that was confusing.
Yes,
Well, it's one of those things where it's the you feel like it's the opposite of what of how you normally would word something.
right, okay.
Or
All
in
right,
other words, the appeal doesn't succeed.
Right.
as far as we know,
Unless town council comes back and says,
Right.
totally screwed it up.
which is fine. There you go.
I'm confused because I could have sworn what just happened was that the appeal carried.
No, 3 people said it did not, and 2 said it should.
Okay, all right.
But what we don't know is whether it takes 4 to say it shouldn't.
Right, okay.
That's what we don't know. But we'll find out. I mean, that's our decision. What it actually what it ends up resulting in, we're uncertain at this moment. Right?
I would think it would have taken 4 to overturn Bob's decision.
That's kind of how I feel.
Right.
Yeah, I think Dave said that. He said that earlier. You asked that question. 4 to 1.
But I didn't understand. Yeah, it was It's back. It's late. It's backwards. Yeah. All right. Let's go on. If we could, please. And I mean, to be honest, Paul and Brad, if you want to leave, I mean, we don't. For this last one, you're welcome to leave. Okay.
You're already here.
There you go. So, all right. We won't do anything else. We won't volunteer you for anything while you're gone. All right, so we're going to move on to the Blueberry Lane. We stopped doing it, Jeff, because you were out of the room. So just to go back, the conversation was around putting a fence up, really for having it possibly be chain link at some portion on the property, since the applicant was agreeable to that. So that would address the line of sight concern, which I think is legitimate for the one abutter on the backside. But I do think Bob is going to have to work with them about the barrier and then the line of sight if they weren't going to do that, because maybe a 6-foot white fence would be too much of an obstruction from their driveway. But if he was agreeable to it, why not?
I would also add that other piece, that it at least closest to the abutter's driveway, it does not get any closer than the existing backyard fence.
Yes.
So that way there's another 7-8 feet worth of distance. I think that would help also.
Oh, I definitely. Yeah. But I think that's what what he was trying to show us on the picture. He was just going to go take that back fence and straight line out to Hemlock and then, right turn to where the pool was going. But on the drawing, there weren't any real measurements to confirm that. And the drawing gave a different impression.
Yeah. So I was concerned about that because the neighbor, a butter, addressed that, and the applicant didn't really follow up on that. So that was a little confusing.
So I would need to know, because again, the drawing that they gave us doesn't show measurements. We would have to be very clear about the measurements of where the fence could go, which of course, but it will need help from staff on how to look at that.
One thing too is, if we want to have staff help us on this, we could, we closed it. We can't continue it. Only because I think what I'm going to ask for is, the fence cannot be, must be set more than 10 feet from the driveway and the first, and show some transparency for the first 15 feet of fence, which gives them a good 25 feet that you're going to see people walking before you plow a car into them.
Right. And on the picture, they have the pool is going to be fenced on all 4 sides within their backyard.
Right? Only by code.
Right. No, but I'm just saying, so the Hemlock is on Hemlock Street, you could have the white fence and then they could still do a white fence across the south side of the pool and then just have chain link for the remaining part of the backyard, which is what they have now with the playground. Because right behind the pool is their playground area.
Yeah, except I think usually with a pool that close to the street, you're going to want a visual barrier on Hemlock, so you're not looking at everybody sunning themselves.
Oh yeah, that's what I'm saying. So like this is the pool. This is the pool, and it's going to have a white fence here and a white fence here, but the rest of the backyard where their entire playground is could be the chain link.
Oh, I did not get the impression they were going to have.
That's a solid fence, Fran, where you had your finger. What he's proposing is that a solid fence all around the pool.
Right, and separating it from when the kids are on the playground. Yes.
Oh, I didn't.
Oh, unless he's not, and see, it's.
Yeah, I did not get that impression.
Oh, maybe not. But see, if you see the X's.
That's all the solid fence.
Right, but is it splitting between the pool and the rec area?
I don't think so.
Oh, maybe not.
But why couldn't we make that a condition?
Yeah. Yeah, because why would, if you're worried about safety, you're going to let your kids play on the swings and they can just jump right in the pool?
No, my impression is that they're completely separated. It's on the complete opposite corner of the property, the playground.
No, it's on the same. It's right behind it. I drove by it.
Yeah.
It's
Oh,
right
it is?
behind it. Yeah.
Oh. Must mean someone needs to be in there with them. I mean,
That means they could never go in their backyard. If the pool is open to the entire backyard, there's no safety. And they definitely gave me the impression that they were talking safety, right? So
it
that
has
means
it has to be completely enclosed.
Right. It's not, I mean, according to his plan, it's not open to the backyard. The pool is completely fenced.
And then the rec area is
within that.
No, the rec area is not. That would make no sense.
On this plan, it is. The rec area is right next to his pool, and it's the pool and the rec area is all inside the fence.
That's what I'm seeing on the. Yeah, I don't see any fence between the rec area and the pool.
Right.
See, I do. So good.
Where do you see a fence, Fran?
Well, if you look at the X's along where it says 37.7,
yeah,
there are 2 X's.
Yeah.
And so that is, to me, going around the, because you see the line comes out a little.
But the fence, that solid black line is the proposed fence.
Yeah.
Which.
Right. And
right.
But
that's what. Yeah.
So that's a 6 feet. Well, I mean, I guess I find that hard to believe that they're going to have the swing set in with the pool when they didn't even want the pool anywhere near any doors.
Yeah, and it's right. It's right up against it. I was looking over by the shed and thinking that was the play area. Yeah, it's butted right up against it. It says rec.
Madam Chair, if I may.
Yes.
Believe it or not, when it comes to pool barriers and fences, if they choose to have the entire backyard, including the rec area and the fire pit and the barbecue area, enclosed in that fenced in area, you can do that. You could literally fence in the entire backyard, and it would qualify as a barrier for the pool. I think what they're proposing is obviously something a lot smaller, but it is okay to include the rec area within the limits of the pool fence.
Oh, I'm not saying it isn't. I just got the impression from a safety standpoint that that would not be something that they were even dreaming of doing. But again, I mean, I guess it doesn't matter in that I still think that what I was going to say is from the back of the pool to the back of the yard, that should be the chain link. And I just thought that they would have, for the privacy piece of it, going horizontal, cutting off those two, because I thought that they were looking for, from a safety standpoint, to block the pool from any access other than, I mean, if you have to alarm a window that's less than 4 feet off the ground, why would you let your kids play on the swings and the slide when they within the same enclosure? It doesn't make sense to me, but I'm fine with it.
I don't disagree with you one bit.
I mean, everyone's assuming, well, I won't say everyone, I'm sorry. People are assuming that the site distance is going to be an issue. We don't even know that for sure. So, you can't take in any new information because you've closed the hearing, but do you at least want to verify that a solid fence would cause a site distance issue?
Yes.
So,
okay,
Fred,
I guess I am familiar with that corner, and I can see I buy the abutter's argument that if you build the fence up to the property line there, or even the 10 feet he said, that what you are doing is saying, okay, you come up the walkway and suddenly you've got 10 feet before you hit the driveway and the car backing down the driveway. And giving another 15 feet of transparent fence there, I think would be a great increase in safety.
I agree.
Yep.
And also, that's not the part of the fence that you really need the screening, because that's not where you're sitting around the pool.
Right.
So I don't think it's a I don't think it destroys their enjoyment of the pool by making that part of the fence transparent.
Right.
I agree.
If the applicant wanted to protect his privacy, he could put a solid fence between the rec area and the swimming pool, perpendicular to Hemlock, and accomplish the same thing.
Right.
Right.
Which is what I thought that they were planning on, which is fine.
That's not what the plan shows, but they could do that and still meet that condition that Mark proposed.
Mhm.
And you might find that when his kids get 6 years older, that they decide, yeah, let's
Right.
Right.
cut it.
Let's go for a swim.
So Mark, you're proposing that that the on the rear corner lot, I mean the rear corner of the lot, that along Hemlock, that 15 feet of that fence be say chain link or something.
Right.
And are you also proposing the fence along the back?
Also 15 feet along the back. Yep.
Okay.
15 feet in both directions, be transparent, visually transparent.
Right. And I think he was leaving that. Yeah.
Not a clear enough term. Let me know.
15 feet in either direction.
Yes.
Right.
I'm in the minority here.
I could have sworn he said that he was leaving the back fence the way it was, but.
No, he was not moving the back fence line.
Oh, okay.
But I think I think that back fence is 4 feet, and he wants to go up to 6 feet there.
Okay. All right. Leslie?
So I'm going to be in the minority here. I don't like that location at all. I think the potential sideline issues, I think it's the 20-foot encroachment, or, whatever you want to call it, relief for a pool and the fence. I think it's just too much. And you're right, he could put the fence there either way. So the fence isn't really the issue, but he wouldn't want the fence if it weren't for the pool. I think the area in the backyard where they could put a retaining wall in looks like a perfect spot. I know it's a little bit, it's additional expense, but I think that's my feeling is they can do it elsewhere on the property. And I'm not in favor of the proposal as it is.
Dick?
I'd just like to say I agree with Leslie. I don't see a hardship here. They can put the retaining wall in the backyard. They can put the pool in the backyard and meet all the zoning requirements. You have two abutters that are against it. The two immediate abutters. I don't think they have the hardship that's required to put this through.
Jeff?
The only comment I would have against that for both Dick and Leslie is I'm not sure that the abutter in the back understands that, the hardship is that you take away not just that slope, but then you put a retaining wall, but then the trees. And I think that if that proposal had been presented to that neighbor, they might have found that more objectionable. So it's not really even just a cost burden to the applicant, but how it's going to change that relationship with that abutting neighbor. That's the way I interpreted it when I looked at that.
You're about the same abutter, Jeff, or a different abutter?
The same abutter with the driveway. I think if it was proposed that slope was going to be taken away, there's going to be a 6-foot fence right along their driveway, right on the property line, as opposed to about 15 feet in now, and all those trees were gone. I may be wrong, but I think they might find that even more objectionable than what is being proposed. I know I would in that position, but I mean, I'm putting myself on that.
All right. So I initially didn't like the idea at all because I thought I didn't like the line of sight. I do think it was concerning to me backing out of a driveway. I have a stone wall and I have to be careful because it's already 4 feet, that I can't see. So I did have issues with that. the idea though that the applicant was agreeable to having chain link fence instead of the white fence would mitigate that, I think was improved the idea that it would be okay. But it really is a small area. If you think about kids running around the outside of a pool, they're going to be, I mean, right up against the fence, and the fence is right up against the sidewalk. But, you know, it's one thing to have a 30-foot setback that you want to get in, you know, again, the 20 feet. But the fact that then in another 5 feet, you're going to put up a large fence. And again, not that it's considered a structure or that it can't be in the setback. It is an obstruction. So it's hard, you know, it's an interesting one, but I don't, you know, I don't know that a smaller pool in a different area, a retaining wall is not, a retaining wall and then a fence in the backyard is going to give you more privacy than those hemlocks because it's going to be solid. I mean, they're just now, you know, lollipops. If they are hemlocks, I was just making that up because of the name of the road.
Better be.
I don't know my trees. So I don't know.
Okay, shall I make a proposal? We'll put it.
Sure. Okay.
Okay, I propose that we grant 22 feet of relief to the 30-foot setback with the conditions that the pool fence be transparent for both the southwestern 15 feet on Hemlock Drive and the southern southwestern 15 feet that abuts the property at I think it's 27 Hemlock Drive.
Second.
Okay, so that's a motion by Mark and a second by Dick. I still don't know what I'm going to do.
May I have just one discussion here? Isn't there a
Sure.
checklist we're supposed to be going through for qualifying in terms of meeting certain conditions to grant it?
For a variance, well, the topography, which we've already discussed.
Shape and
okay?
soil.
The shape of the property, the soil, the
I also don't know where the what do you call it?
Septic?
The septic system is.
He said it was in the front.
Yeah.
Which front?
He said it wasn't an issue, I guess.
The other front, Blueberry.
The Blueberry Lane front.
On the Blueberry, so yeah.
Anyway, I feel like we should go through the
actual
formal
steps.
process, especially if people are having a hard time figuring out how to vote. It might add clarity.
Oh, okay, but for a variance, we don't, well.
Right, it's not the special permit criteria. It's
Right.
the
variance.
variance criteria is, you know, is there a hardship due to shape, soil, or topography?
And the topography, in that if he were to put it in the back, he'd have to cut in a large amount of the, and put up a multi-foot retaining wall.
Right. So that is the hardship. The cost of it is not considered part of the hardship, but the land itself would have be more difficult to dig up.
Right. I
and
mean,
to place, yeah.
Right. He's saying due to the topography of the back, that's why he wants to put it in the side.
Yeah.
Okay. I'm not in favor though of the 22 feet. I know you like to give wiggle room, but I already feel like we're getting, I mean, if they can't get it in the 20 feet, I don't think they get it.
All right. Well,
that's just me. But
I just get the impression that they're not going to get it. But
no, well, no, I mean, no, I mean, I would say that to Leslie's point, if it's purely on the variance of the topography and the and the soil of the backyard versus this side front yard. If we can mitigate the sightline issues with the chain link fence, I would say fine, but 20 feet is it. If they can't do it in 20 feet, they can't do it.
Okay.
So did you want, will
I
you
would
amend your
amend my
motion to 20 feet with the chain link? Mark?
What's that?
I don't think so.
Will you change your motion to 20 feet, not 22?
Yes, I would agree to amend my motion to 20
His
feet.
pool's gonna be
Alright.
right up against his.
Second.
Dick? Okay, all right. So now we have a motion to put it within 20 foot of the setback, with the 15 feet on either side of clear, whatever you had said, fencing, in accordance with whatever Bob says they have to do for the barrier. Okay, roll call. Mark?
I'm sorry, 20 feet, you said?
20 feet, yes. Okay, any further discussion? Okay, Mark?
Aye.
Dick?
Nay.
Was that a nay?
Nay. It was a
Okay.
nay.
Leslie?
Nay.
Jeff?
Aye.
And Fran, aye. Okay.
So you need a 4-to-1.
So it fails 3 to 2.
Yeah.
Oh, really? Oh, okay. I didn't know
Yeah,
that.
a variance needs 4 to
that's
1.
true. Yeah, true. All right. Well, there you have it. Okay. All right. Do we need to talk about town meeting zoning amendments or approval of minutes or any of that other good stuff?
No, unless anyone read the minutes, there's 2 sets that we've sent out.
No.
No, and I'm just going to put the zoning on, as a standard,
Okay.
doing the same thing with planning board. So, we can talk about, at your next meeting. We have a couple things that we want to do in-house just as far as housekeeping, but, I'm hoping, as I hoped last year, that there wouldn't be any zoning amendments because you want to
Yeah.
enact the master plan.
All right.
And then do your zoning based on that. But
Okay. Well, all right. So, one other thing. So did everybody see the, decisions that I don't think you got anything back, Kathy, on the one
no,
you asked for?
and
Okay.
I didn't expect you to.
Okay.
Actually, Dick provided me some comments that
Okay,
I
good.
need to
Okay.
incorporate into 5 barefoot to
Okay.
expand the hearing section.
Okay.
And then I've just sent those out the past couple of days, so I
Okay.
didn't expect anyone to have read all of them.
Okay.
But we're just trying to get those out to you. So we should have the rest of September's decisions by the end of this week.
Okay. All right. Thank you.
And then we'll follow up with these 3.
Okay. And anyone have any pressing business between now and the 24th that would prevent them from walking over on Hudson Street?
So I'll just throw out some dates over the next couple of days.
I can do it most weekdays. I could not do it on a Saturday.
Okay. I can do most weekdays. I am not here from the 11th, 12th, and 13th of November.
If it's early in the morning, I can do it most days, but I work from 10:30 to 7 Tuesday through Saturday, and I work on Mondays too. So Sunday's my only day that I'm completely free.
But during the week before 10:30?
I'd have to be back at work. I start work at 10:30, although on Tuesdays I start at 9.
Okay. Well, sun up is at 7:15, guys.
The only day I'm bad is October 30th.
Yeah. Well, and I'm busy November 3rd, I will say.
What's happening that day?
Hopefully,
I can make most days, so.
We hope a lot. Okay, so I'll still put it. I probably won't be tomorrow, but Thursday I'll send everyone. I'll give you a couple dates, and we'll go from there.
All right. Sounds
Great,
like a
thank you.
plan. All right. Do I hear a motion to adjourn?
Motion to adjourn.
Second.
Okay. Roll call. Mark?
Aye.
Dick?
Aye.
Paul?
Aye.
Fran? Aye.
Jeff.
I'm going to
aye.
say aye just